and we should be live now.
Great, thank you very much. Welcome this morning to the Energy, Utilities, and Technology Committee. I am State Senator Mark Lawrence, representing District 35, which is Southern York County, along the New Hampshire border, Kittery, Elliott, South Berwick, half of Berwick, York, and Ogunquit. I'm going to ask the members of the committee to introduce themselves briefly, and then I'm going to go over a little bit of pre-hearing information for people, but we're here today for a series of public hearings. And we will begin with our Republican House lead, Representative Wadsworth.
Good morning, everybody. My name is Nate Wadsworth. I represent District 70, Southern Oxford County.
And then we'll go on to Representative Cuddy.
Good morning. My name is Scott Cuddy. I represent House District 98, and that is Winterport, Frankfort, Searsport, and Swanville.
Next is Representative Foster.
Good morning. I'm Steve Foster, representing District 104, which includes the towns of Dexter, Garland, Charleston, Stetson, and Exeter.
And from the Great North, Senator Stewart.
Morning, folks. I'm Trey Stewart, State Senator in District 2, 51 communities in Southern Aroostook and Northern Penobscot counties, including the town of Dyer Brook.
And then we'll go to Representative Ziegler.
Good morning. I'm Representative Paige Ziegler from District 96 in Waldo County, the 7 towns of Belmont, Liberty, Lincolnville, Montville, Morrow, Palermo, and Searsmont.
Next is Representative Wood.
Good morning. I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
And next we'll go on to my co-chair. I should have introduced him first, Representative Seth Berry.
That's quite all right. Hi, everyone. Seth Berry. I represent House District 55, Bowdoin, Bowdenham, almost all of Richmond, and beautiful Swan Island on the Kennebec.
And last but not least is Representative Grochowski.
Thank you so much. I was getting really nervous. I'm Representative Nicole Grochowski. I serve the people of Ellsworth and Trenton in House District 132.
Great. We have with us today our clerk, Jordan, and we have Deirdre Snyder and Dan Tartikoff. They are our 2 analysts from the Office of Policy and Legal Analysis. And I believe, Dan, you are starting off with the first bills this morning. Is that correct? Okay, so let me go over a few rules about presenting to the Maine legislature in a public hearing. This is a public hearing, and the format is to allow us to gather information. This is not the time for us to debate or discuss the bill. It's more time for us to solicit information from public and interested parties. So you will have a chance to speak, a chance to present testimony, both written and verbal. We ask that when you do testify, you limit it to 3 minutes. If you have additional things you want to testify to, please put it in writing. And always, if you're testifying, put it in writing, because we do refer back and those documents do become part of our official record, and we do refer to them during the work session. We will be having a series of work sessions on these bills, and that will be the time for the committee to debate and discuss the bills to go over. And that's kind of a closed, not a closed session, but a discussion among committee members, where the only people are participating are the committee members discussing the bill, debating it, and those who we reach out to, who we need more information from, we allow to speak to the work session. But it's really not the time to present additional arguments. You should prepare today just to present your position on the bill and any of the details you want us to know. It's useful for me to remind people that video and audio will be live streaming today on YouTube, and the comments of members, the analysts, and whoever may be invited to answer questions will all be picked up by microphones. And it's also being recorded and becoming a permanent record of the legislature. Participants should always mute themselves when they are not recognized by the chair to speak. And if you wish to testify, I'd ask you to please state your name after you're recognized, your residence, and your organization. That's so we know who you're representing. And we do have sometimes people who come before us representing organizations, but they're before us on this day only as individuals. So we ask you to represent whether you're representing an organization or you're speaking individually as to your own position. I will recognize people on the following order. We'll first go to the sponsor of the bill. Then we will go to any co-sponsors who want to sign on to a bill. Then we will go to proponents. Then we'll go to opponents, and then we'll go to people who wish to speak neither for nor against, but wish to simply provide the committee with additional information. And again, if you have written materials, please submit them to the committee so that we have them for our hearing and our work session. And just as kind of a procedural reminder to help Jordan out, Jordan each day has to schedule people, send out links, get everything set up for the day before. So we ask people who are expecting to testify on the bill to do that before 10 o'clock on the evening before, so that Jordan has that information the evening before or right in the morning to start off. If you call in the morning, often Jordan is working on setting up the hearings for the day. So it's difficult with those interruptions, or if you email him, it's difficult for him to get back and to finalize the setup for the committee. So that we ask you to be kind to him and get it done the day in advance. Today, we're going to hear testimony on a following number of bills: LD 840, LD 1025, LD 1079, LD 1100, LD 1116, LD 1328, and LD 1332. I expect to go in that order because I haven't heard any requests to change the order from committee members or anything like that. So we will be going to that in that order, but it may be subject to change during the day. Oftentimes sponsors have bills in other committees, things they have to stagger throughout the day. So we try to accommodate the legislative schedule to keep things moving along in a smooth fashion. And you will see today people jumping in and out of the Zoom conference or putting up a screensaver. Members of the committee, some of them serve on multiple committees. For example, Representative Wood serves on this committee and Legal and Veterans Affairs, and both are very busy committees. So she'll be often stepping off between meetings. Also, members of this committee have bills they need to present or work sessions they need to monitor on their bills in other committees, so they may step off periodically. It's not a reflection on the subject matter of this bill. It's a reflection on how busy and how stretched we are as legislators to get everything done. And that's why we do ask you submit written testimony, because oftentimes people will come back and either view the live stream again or look at the written testimony that was submitted. So that is, in fact, very helpful. On this procedure today, I want to make it clear, since we're doing it on Zoom and it's a little bit different format, we've done this a lot, obviously, this year, but to those who are new to testifying, we followed the procedure that would be in the committee room. So if you get up to testify and you're made a panelist and you testify, there'll be a series of questions that the committee members can ask you, and the purpose is not to debate with you, but to elicit information that's going to be important for our work session. So they will be asking questions. Once you're done, you'll be eventually demoted back to being attendee. And I shouldn't say demoted, just changed back to being attendee in the committee room. Once that happens, you will not have an opportunity to speak again. And you will not have an opportunity, if you hear somebody else ask the question, to answer that question for them. So it's a one and done procedure where you get up, testify for your 3 minutes, and you answer your questions That's not to say you can't submit additional written comments to the committee, and they do get read. The chat room feature that we have on Zoom is we use it only for scheduling questions only and scheduling matters only. We do not ask you or members to post anything substantive in that chat room. And that chat room is part of the public record, just to let you know. So we're going to be starting off with our first bill, and our first bill will be presented by our very own Representative Berry, who's going to move on the Zoom screen from being a member of the committee to a presenter of the bill, but you won't notice any difference. So he's going to the virtual podium right now, and he is going to be presenting LD 840, an act to prevent power line electrocutions. Representative Berry.
Thank you very much, Senator Lawrence, fellow members of the Energy, Utilities, and Technology Committee. Again, my name is Seth Berry, and I represent House District 55. I'm here today to present to you LD 840, an act to prevent power line electrocutions. This measure will help to prevent electrocutions by creating parity between main electricity and gas utilities regarding their liability for the hazards associated with an all too frequent situation, poor maintenance of infrastructure. There is, in fact, a tragic story behind this bill. Others here today will be able to speak to it a bit more. But in 2002, a young man, 18 years old, working at a boatyard in Penobscot, was badly hurt and 43% paralyzed. This story moved me, by the way, because my sons are just about the same age, in addition to just the inherent tragedy of the story. The young man, Brian Smith, was unstepping and lowering an aluminum mast at the time and hit a power line that was at 30 feet of clearance, but should have been under PUC rules, which, as you know, have the effective law. It should have been at least 45.5 feet. It was a miracle that Brian Smith survived. As reported by the Bangor Daily News in a 2013 article, and I quote, "The case stemmed from an October 31st, 2002 accident at the boatyard that left Brian Smith, then 18, with permanent injuries. Smith of Bangor was injured when the mast he was lowering from a customer's sailboat came into contact with an overhead 34,500 volt power line owned by Central Maine Power, according to previously published reports. Smith received workers' compensation benefits through Devereaux Marine, his employer, and sued Central Maine Power for negligence in July 2007 in Penobscot County Superior Court. A jury-waived trial was held a year later, and in November 2008, Superior Court Justice Michaela Murphy awarded $4.89 million, $3 million in damages for loss of enjoyment of pain of life, pain and suffering, more than 1.1 million in lost earnings, and $783,000 for past and future medical and rehabilitation expenses. Quote, "The accident was caused by the fact that this 35-foot 4-inch mast with its butt end held 3 feet off the ground at an angle of less than 90 degrees hit a power line that was set at 30 feet and not at 45.5 feet as required by law," unquote, the justice concluded. The Maine Supreme Judicial Court upheld Justice Murphy's decision, February 9th, 2010. And a week later, CMP paid the judgment, which, including interest, totaled more than $6 million. A short time later, CMP filed a complaint against Devereaux Marine and a motion to attach a lien to real estate owned by the business, according to the Supreme Court's ruling. And this is on a later case. So in short, in this first series of cases, the courts found CMP to be liable, and they paid $6 million. But in a later case brought by Central Maine Power with the help of the Edison Electric Institute, which is, as you may know, the association nationally for private electric utilities, the law court effectively determined that CMP was immune from liability and could under no circumstances be held responsible for the $6 million in damages, under no circumstances. In the end, the boatyard and or the workers' compensation system had to pay all costs and CMP not a penny. A settlement was reached in this case that allowed the boatyard to stay in business for a time, but with cripplingly high workers' compensation ratings. So in this case, the utility industry nationally effectively established that under current Maine law, negligent, and this is true in most jurisdictions, unfortunately, negligent management of highly dangerous infrastructure is highly unlikely to result in any consequences, even when a trial clearly establishes their negligence, and even when the resulting injuries are devastating or even fatal. So the language this bill puts forward is the solution. Its language is transposed directly from Maine law pertaining to gas utilities and their safety and liability. And its language specifically noted, effectively recommended by the law court in their decision on the case. The language would require that all parties be held liable according to their share of the responsibility. Imagine that. If this had been the law back then, the boatyard might not have had a massive hit to their workers' comp rating and enormous legal costs, and might still be in business. As the law court wrote in the subsequent case, CMP Company versus Devereaux Marine, 2013, quote, if the legislature intended to allow or provide for allocated liability, shared responsibility, in other words, instead of indemnification in section 760, it could have used clear language to achieve this goal. In a similar statute, which was enacted to protect the public from fires or explosions that may be caused by natural gas leaks, the legislature has done just that, unquote. And that's from paragraph 23 of the decision. So in their reluctant decision to absolve CMP of all responsibility and of all the $6 million in penalties that they had paid, the law court also provided us, the legislature, with the guidance we need to fix the problem by allowing liability to be shared, as we already do for natural gas. This bill will ensure that both the utilities and anyone who works in proximity of their infrastructure or their employer are all more responsibility for safety, and especially for that of workers who may come into contact with lines, as so tragically Brian Smith did in 2002. Thank you for the opportunity to testify and present this bill. I look forward to any questions and to the testimony of others who were more directly involved.
Are there questions for Representative Berry regarding this bill? I do have a couple. So you're trying to establish joint and several liability on behalf of the utility, is that correct?
That is correct.
Okay. And can you just tell me why this bill was so long in coming before the legislature?
That's a great question, Senator. And I honestly don't know the answer. I came across this case and the effective recommendation, if you will, of the law court that there's a clear path to correct this problem last year. So it was too late to present a bill, and I decided to bring it at this time. I also, out of curiosity and just a real feeling that something had gone wrong here, I did reach out also to those who had been involved. I have not been able to reach Mr. Smith to hear his account. Brian Smith is a fairly common name, and I'm sure he's in the book somewhere, but I couldn't find him.
Okay. And perhaps for our discussion and for the committee's deliberation too, the question that occurs to my mind is whether this belongs in judiciary, since it deals with tort liability and joint and several liability. So, but we'll complete the hearing and then begin to discuss that. Any other questions? Go ahead, Seth.
If I may, just I know there wasn't a question there, but Senator, your question about why this didn't come sooner is interesting. The law court points to the statute that was originally enacted, I believe, in 1995 by the legislature and without debate. So there really has not been discussion of this issue in my reading of the record ever, with the exception of that law that quietly passed in 1995.
Right. It'd be also helpful to know if you know of any other companies or any other situations where this liability is eliminated. We do have the Maine Torts Claims Act, which protects governmental entities from tort liability. So it's really a much broader question too. Other questions from the committee? Representative Grochowski.
I just wanted to check, is this would amend chapter 35A, correct, which is within our jurisdiction?
Correct.
Okay.
Other questions?
Yes, the Overhead Power Line Safety Act, I believe, is the section of statute to which we're referring. So it is not typically something that judiciary would look at.
Yeah, we can discuss it in work session. My point is the subject matter is really tort liability and tort liability responsibility policy in the state of Maine, which falls under judiciary, regardless of where it's put in the statute.
Thank you.
Okay, other questions for Representative Berry? Seeing none, thank you. Are there co-sponsors who wish to testify? Yes, Representative Carlo. You are a co-sponsor?
I am.
Okay, go right ahead.
Thank you, Mr. Chairman and distinguished colleagues on the Joint Standing Committee on Energy, Utilities, and Technology. I am Representative Nathan Carlo, and I'm pleased to be with you this morning to present brief testimony in support of legislation I have co-sponsored with Representative Berry. The sponsor has expressed to the committee this legislation was written in a very sorrowful context. Truthfully, this was an incident that claimed two victims, both the worker who suffered paralysis due to electrocution and also the owners of the small Maine boatyard who were literally driven out of business despite the electric company's overwhelming negligence. If this case were litigated in the courtroom of common sense, it would have very clearly been Central Maine Power who would have been held liable for these damages. And while I won't further restate the somber circumstances that prompted this legislation to be submitted, I will say that the incident, as well as the ensuing court battles, was a failure on the legislature's part to conform electric safety regulations with other utilities. This bill establishes much needed parity that ensures that the issue which has been outlined by the sponsor does not recur. More than 4 decades ago, the Maine Supreme Court articulated that the paramount objective of a utility regulation was to ensure that the public receives an adequate service delivered in a safe and reliable manner. I want to be clear that this bill is just as much about safety as it is about who shares liability. Accidents do happen, and as unfortunate and upsetting as they may be, we will never be able to legislate away facts of life. The question here is whether or not this infrastructure would have been made more secure if statute held electric companies liable for damages. Effectively, current law extends unqualified immunity to electric companies, even in cases where their infrastructure does not meet safety guidelines imposed by statute. At this point, it's a profoundly regrettable oversight. But should the committee not approve this bill, I would then fear that it would become a dangerous precedent. For those reasons, I encourage my colleagues to vote in favor of this bill, and I would be happy to take questions from committee members at this time.
Are there questions from the committee members? Seeing none, thank you. I believe that's all the co-sponsors. I don't know if we expect to hear from Representative Fecteau. Representative Grochowski, did you want to speak? Okay. So we'll go on to people testifying in favor of this bill. And I believe we have Barry Mills who wants to speak in favor. Barry?
Thank you, Mr. Chairman. and to members of this committee. Thank you for this opportunity to correct an anomaly in our law. It's an anomaly that is capable of inflicting great injustice. For the record, my name is Barry Mills. I was an attorney for Brian Smith in the underlying litigation against Central Maine Power Company. I also represented Devereux Marine in the ensuing litigation that came out of the Brian Smith case. So far as I know, this is the only instance in which the law has been invoked since its passage in 1995. That does not mean it's not going to happen again tomorrow. It is important to emphasize that Central Maine Power and Devereux Marine shared fault for this accident. They both were negligent in their own ways. But Devereux Marine met its responsibility. It carried workers' compensation. And Brian received the benefits to which he was entitled under the workers' compensation law. The statute as written, however, permitted Central Maine Power Company to avoid all responsibility. It's true that it paid Brian Smith what was owed to him under the judgment, but it was, as you know, entitled to seek full reimbursement from Devereux Marine. Devereux Marine would have paid twice, once under the workers' compensation law, and again to reimburse Central Maine Power Company. Both were negligent, but Devereux Marine would have paid twice. Central Maine Power would have been held, in effect, harmless. Yet it shared responsibility. And in fact, I would say it had primary responsibility under the circumstances. The Overhead High Voltage Line Safety Act, which we're coping with today, has been passed in many and perhaps most states. Its purpose is not to enhance the safety of anyone. Rather, its purpose is to insulate power companies from the consequence of their own negligence. Central Maine Power was the ostensible plaintiff in the case against Devereux Marine, but it was not the real party in interest. Central Maine Power's case was controlled, and I would be willing to wager it was funded by Edison Electrical Institute, an association that represents all U.S. investor-owned electrical companies. They were the power behind this case, and they were out to prove a point. They saw the case that Brian had won against Central Maine Power. It was reported in the report from the Maine Supreme Judicial Court, and it wanted to perhaps establish this point that power companies are entitled to full reimbursement, notwithstanding their own negligence, and they were out to prove a point. The case was eventually settled after that law court's decision in the Devereux Marine case, but we agreed to a judgment that we wouldn't have to pay. They got some money out of Devereux Marine's insurance companies, and then they entered a satisfaction of judgment. So in the end, it worked out the best we could do for Devereux Marine. But the whole process was merely to prove a point and to flex some muscle. It's a near universal principle in our law that people, including corporations, are responsible for the harm that they negligently inflict on others. You and I are, and in all other instances, to my knowledge, that is true. The Overhead High Voltage Line Safety Act violates that principle. The outcome under this law rides not on fairness or justice, but on which side has the more effective set of lobbyists. But even as revised, however, the law contains an element of significant unfairness. True, as revised, there would be joint and several liability, which is a movement toward a fair result, but it doesn't get there. The proposed amendment would make both parties negligent jointly and severally liable for paying the cost of the injury. But remember, however, Devereux Marine was covering the cost of workers' compensation. Generally, under our workers' compensation law, employers who furnish workers' compensation benefits are immune under the tort law. I suggest this principle should carry over to overhead line injuries. I have submitted a written testimony, and in that written testimony, I have made the suggestion that you add the following text or something similar to it at the end of the proposed revision. The wording would read, provided, however, that employers of injured parties shall be immune from liability to the extent provided under Maine workers' compensation law.
And just to let you know, Mr. Mills, you are running up to the 3-minute limit.
Okay, and that language would bring the Overhead Line Act into conformity with legal principles found throughout our statutes and common law. I'd be happy to answer any questions that you may have.
Thank you. Are there questions from the committee? So, Mr. Mills, as I understand what from Representative Berry's testimony, during the trial, CMP and Devereux were found joint and severally liable, correct?
No, they were not. The trial that Brian, there was only one trial. Brian Smith's case against Central Maine Power Company. Devereux Marine was not a party to that case. Andrea Devereux was very helpful in her testimony. They were not a party. The verdict was only against Central Maine Power. That prompted the second case brought by Central Maine Power, at least under its name, against Devereux Marine to recover what it had paid Brian under the judgment.
Oh, okay. So Central Maine had already paid the judgment, and Central Maine Power brought the case against Devereux.
That's correct.
Was there a reason why Devereux wasn't brought in?
Electrical Institute.
Was there a reason why Devereux was not brought into the case?
Yes, because it's immune under the workers' compensation law. Brian could not sue his employer under Maine's workers' compensation law. He could only sue Central Maine Power. And that brings the anomaly. If Brian can't sue, if an employee cannot sue the employer, why should a third party be able to sue that employer? If the employer is immune, the employer should be immune. And that's what it is under workers' compensation law. And there should not be an exception to that rule without very good reason.
Okay. Other questions for Mr. Mills? Representative Berry?
Thank you for the forbearance, Mr. Chair. And Mr. Mills, I was just wondering, is it possible for you to turn on your video, or is that not an option?
No, I don't know why my video is not. Oh, wait a minute. Yeah, there it is right there. Start video. I'm sorry.
Oh, great. Okay.
I was wondering why I was not appearing on the screen. I mean, I put a necktie on, especially for this occasion.
Excellent. That's much better. Thank you. And I do have a question, a more substantive question, which is just to clarify to follow on the previous discussion. Under workers' comp law, an employer can't be sued, but their experience rating is impacted, and that impacts their workers' comp rates going forward if there is an injury on the job site. Is that correct?
That is correct. Now, I'm not a workers' compensation lawyer, and I don't claim to have expertise, but that is a fact that they do have experience rating. And you can see the piling on that would have happened here with Devereux Marine had we, in fact, if they actually had to pay the judgment, that would have been the end of the world. But there is a piling on of the employer. That is, they pay workers' comp. Their rating is impacted. Now they're responsible for the full amount of the judgment, but they're only partially responsible for the accident. And this is why I suggest that you add language such as what I have put in my written testimony.
Thank you.
Okay, other questions for Mr. Mills? Seeing none, thank you very much.
Thank you.
We'll go on to our next person testifying in favor of this bill, Andrea Devereaux. Andrea, are you able to get on?
She's on the panel, but I don't see
Yep.
video and it looks like she's muted.
Can you hear me?
We can hear you now, but we don't have your video yet. Oops, I think we lost you again, Andrea. Oh, there we go.
Okay. You should have both
ahead.
now.
Yep, go ahead.
Okay. Senator Lawrence and distinguished members of the Energy, Utilities, and Technology Committee, my name is Andrea Devereaux, and I reside in Penobscot. I am here to speak in strong support of LD 840, an act to prevent power line electrocutions. My family business, Devereaux Marine, was started in 1985. At the time, it had power lines on 3 sides of the boatyard. One of them, a 3-phase line, and all 3 were about 30 feet above the ground. As you have just heard from Representative Berry, a terrific accident occurred on October 31st of 2002. A young man working for us, Brian Smith, was very severely injured when a mast he was unstepping came into contact with a line. We had been in business for many years, over 25 actually, and had never had anything like this happen. It was a tragic day and I will never forget it. It was a miracle Brian survived, but his injuries left him 43% paralyzed. When the case went to court, Justice Michaela Murphy decided that Central Maine Power had violated its standards for vertical clearance. The line height was supposed to be at 45.5 feet, not 30 feet. Central Maine Power also lied on the stand. These standards were not simply guidelines, but were clearly required by PUC rules for public safety. Central Maine Power tried to appeal but lost again, and they were required to pay $6 million in damages to Mr. Smith. Central Maine Power then found a technicality. In 2010, they sued me and the yard manager for everything I owned, not just the business, but everything. It was very scary and devastating. In the end, I had spent over $10,000 in legal fees. My lawyer in that case was Barry Mills. I understand that he will testify or has testified. I only know that this was a tragic and devastating experience for Brian. And then, thanks to CMP, it was also devastating for me and my family in a different way. I am here today because I hope you will change the law so that Central Maine Power at least shares more responsibility for the hazards their lines can create when they are poorly and illegally maintained. Maybe then a future tragedy like this will be prevented. Thank you for listening, and I'll try my best to answer any questions.
Are there questions from the committee? Seeing none, thank you very much, Ms. Devereaux. We'll now go to testify to individuals testifying against this legislation. And we have Deb Hart, who I believe is testifying on behalf of the consumer-owned utilities. Deb?
Good morning. Can you hear me?
Yes, we can. Thank you.
If I say that one more time, I'm just like, I hate that phrase. Good morning, Senator Lawrence, Representative Berry, and members of the Energy, Utilities, and Technology Committee. My name is Deborah Hart, and I'm a resident of Manchester, Maine. I own Hart Public Policy, and I'm speaking to you today in opposition to LD 840 on behalf of my client, the Dirigo Electric Cooperative Companies. Currently, the Overhead High Voltage Line Safety Act makes clear the liability of a person to the owner or operator of the overhead high voltage line and third parties, if any, for damages to its facilities, along with injuries to persons and all costs, expenses, and liabilities incurred as a result of contact with an overhead high voltage line. As we read LD 840, it would add comparative fault language in an attempt to shift some liability to the owner by asserting that damages were caused by the combined fault of the person and owner or operator of the overhead line. This new provision would allow a party that caused the damage to assert that the line was not operating to code, the line had been not sufficiently maintained, or a number of other scenarios to shift partial blame to the owner, to the line owner, which places pressure on utilities and their insurers to settle claims instead of engaging in costly litigation. I won't read the rest of my testimony. That's the thrust of it. Certainly the testimony that you've heard prior to this is sad, and it's hard to stand up here and assert that we feel that we have protections for everybody. Overhead high voltage lines are obviously things that can cause severe damage. And I will stop with that. I thank you for your attention. And if you want any further information on behalf of my clients, I'd be happy to provide that to you.
Great, thank you. Are there questions for Ms. Hart? I do have one, and it's for you and also for the CMP attorney, and also for perhaps for our analysts as we begin to try to figure out this bill. So if now under the Supreme Court ruling, the utility is exempt and we no longer exempt them, are we then reopening the places like Devereaux Marine back up to liability? Because could not the utility then countersue if the Marine had done something too close to the utility line or something like that, and now we've extended the liability back to the marina? Do you follow what I'm saying, Deb?
Sort of. Could you say it again? I was trying to write when you were speaking. So
my question is under this scenario, and this was a workers' comp injury, so it's unique. It could have been easily a, somebody not working for Devereaux Machine or a contractor or something who was injured. But under this theory, CMP was sued for liability other than the workers' comp liability.
Correct.
And when CMP was found immune, they asked Devereaux to pay its judgment afterwards. If we, under the Supreme Court ruling, it seems now they're saying that CMP or whoever, the utility, is immune from tort claim. If we are now saying they're now open to tort claim, can the utility then counterclaim against the marina for tort liability and something they did in not properly protecting the line area from its workers, and thereby seek the protection from tort liability that is currently given to both them and the marina by the decision?
Got it.
You follow what I'm saying?
I do. Thank you.
Okay.
Thanks for restating it.
So that's a question for you guys, and we're getting into kind of complex tort liability questions, but also a question for our analysts to prepare for the work session.
Thank you.
Any other questions for Ms. Hart? Okay, we'll go on to our final person testifying against this bill, and it's Kenneth Farber of Central Maine Power. Kenneth, do you have your microphone on?
I was unmuting the wrong location. I'm technically challenged here, so I apologize. I also, before I start, I have to say my son's bedroom is not the best witness stand compared to the other rooms that I'm viewing here today. I'll have to upgrade his room for another hearing. Good morning, everyone. Senator Lawrence, Representative Berry, members of the Joint Standing Committee. My name is Ken Farber. I'm Senior Counsel at Avangrid Services Company, and on behalf of Central Maine Power Company, I'm presenting testimony in opposition to LD 840. The bill notes that the bill summary notes that the bill provides an exception to the indemnification provision of the law by purportedly allowing for allocated liability if damages to facilities and injuries to persons is caused by the combined fault of a person and the owner or operator of an overhead high voltage line. As a matter of policy, we disagree with this proposed change to Section 760 because an employer who allows their employees to work near the lines is in the best position to avoid accidents in the first place by notifying the electric company and seeking arrangements for the work to be performed safely. Importantly, an electric company, an electric utility may not even know an employer is allowing work to occur near a high voltage line if that employer does not provide the notification. Through such notification, the electric utility can mitigate risks that might otherwise not have been addressed. Also, the proposed amendment does not accomplish what the summary indicates it will do. The bill does not, in fact, provide for allocated liability. Allocated liability is legally viewed as some form of comparative negligence, proportional liability based on the relative degree of fault of co-contributors. In contrast, however, the proposed amendment would establish joint and several liability. Joint and several liability legally means that where responsibility is jointly shared by two or more parties, a wrong party may sue any or all of them and collect the total damages awarded by a court from any or all of them. This is completely the opposite of proportionally based liability. The joint and several liability language would eliminate an electric utility's right to indemnification from an employer or other party who causes someone to work near a high voltage line and fails to follow the requirements of the Act if the utility is somehow negligent. And that's regardless of the degree of that negligence. Even if the employer's compliance with the Act could have provided the utility with an opportunity to mitigate the risk of an injury. This would reduce the incentive for such employers or other parties to follow the notification requirements of the Act, even though they are in the best position to ensure the safety of their employees. The current law incentivizes them to act safely with the financial risk of potentially having to indemnify the owner of the power line. The proposed amendment would reduce safety by removing that key incentive. Thank you for your consideration, and I'd be happy to answer any questions.
Are there questions from the committee? Representative Grochowski.
Yes, thank you, Mr. Farber, for your testimony. I have a few questions. One, what if this employee were self-employed and didn't have a company that CMP could turn around and ask to pay for the damages? Would the court case have looked like asking that individual to pay for the damages, to repay CMP for the damages? How would that work? It seems like you all were protected because there was a company to fall back on.
Yeah, I'd like to provide a more detailed written response to the question, but I think the issue that you're getting to, the question raises, I think under the statute, would that person who caused themselves to come into harm's way, whether they would be able to claim that the company somehow violated the provision. And as I read the statute, whether it's an employer or another individual who comes into contact with the line without prior notification of the company, they would have to, in essence, indemnify the company. So in this instance, if it's not an employee, but it's someone else who fails to contact CMP and notify CMP that they're going to be in harm's way, they are not able to then receive compensation from the company. I think that's the that's the rationale. The rationale behind the statute itself is that individuals and corporations who are going to come near a CMP line have an obligation to notify the company that in fact that is going to happen, so that the company can then take measures to mitigate against the risk of injury to those individuals. And it's the one thing that one of the things that CMP takes very seriously in terms of protecting both its employees, other workers, as well as the public as a whole from the risks of electrocution as a result of high power, high voltage lines. I can provide more written comments on that as well. I hope that responds.
If I may, Mr. Chair. Thank you. Yes, please do provide written comments in general. We'd like to see written testimony for the record, and I noticed
actually you should
submitted any.
I'm sorry, you should have our written testimony. I apologize if you haven't received it. And the written testimony goes into more details.
Yeah, perhaps you could get in touch with our clerk about that. It's not in the system that we use for some reason.
Okay, I apologize.
And there is a delay, Representative Grochowski. I noticed it yesterday too in another committee. There is a delay in LIO getting testimony up onto the website.
Okay, I think it depends on which website you're looking at, but we don't need to discuss that right now. I see you signed up to testify at 7:21 a.m. and there's no accompanying written testimony with that submission, but we can sort that out later, I'm sure. Another question I had, you keep mentioning that if the company were to notify CMP that they were engaging in what I would call pretty regular business for a boatyard, to be stepping and unstepping masts, would CMP then decide, go out and look at the site and realize that its line was hung illegally low? I mean, what would have changed? And you might not know the answer to that question, but what would CMP have done differently when, quite frankly, their line was hung in an illegal fashion? Why is it on the business to notify CMP that they are breaking the law?
Representative, I don't know the details of the Smith case. I wasn't involved in that, but I think the importance of the statute is that if the utility is notified in advance, the statute provides provisions for which which allows for that notification and then allows the utility to establish mitigation measures that would prevent an accident from occurring. And that's why the statute is so important and the notification provision is so important, without going into the details of what happened in the Smith case, but that's how it's supposed to operate.
Representative Grochowski.
One other question, if I may, Mr. Chair. Thank
you.
So the language that's being proposed here comes directly from the gas statute, as the law court recommended if we wanted to address this issue. It seems to me that CMP, owned by Avangrid, has a lot of gas companies that do business in this region. And I wonder if you could discuss for us or speculate, it's not a great question, I'm sorry, but how is this fair in the case of gas companies, but not fair in the case of electric companies to your client, your larger client?
That's a good question, and I will provide you a written response to that question.
Thank you. I'll look forward to that.
Any other questions? Representative Foster and then Representative Carlo.
Thank you, Mr. Chair. Thank you, Mr. Farber, for your testimony. I have a question that I'd like, if you can, it's a bit speculative, but as I consider whether this is the appropriate committee to hear this bill or not, I'm trying to look at the connections to EUT, if you will. I'm wondering if the settlement had gone the other way and CMP had been forced to pay the damages of the original finding, would those costs have gone on to ratepayers or to shareholders? Can you answer that for me?
I'd have to provide you a written response to that, but I think my understanding and is that Central Maine Power paid the damages to the plaintiff in that case. The issue was whether we would seek or were entitled to indemnification from Deborah Marine after we had paid those damages to the plaintiff in that case. As for whether it's a ratepayer or shareholder issue, I will get back with you on that answer.
Thank you.
Representative Carlo.
Thank you, Mr. Chair. My friend and colleague, Representative Gorhowski, made a very interesting point that this is fairly regular business for a boatyard to be conducting. So my question to you, Mr. Farber, is do boatyards under sagging electrical lines need to notify CMP every day or 72 hours in advance?
I'd have to know the facts of the individual case. I understand what you're saying, but I think that's a hypothetical that I'm not prepared to address. I'd be happy to provide a written statement as to how we deal with boatyards in general. I'm not familiar with that myself. A good question, though.
Thank you.
Great. Representative, I'm going to actually have to turn it over. I have to head out to get my second shot. So I'm going to turn it over to Senator Vitelli to continue. We have Representative Carlo waiting to ask a question. And then I believe that will, this witness will end the testimony on this bill. Senator Vitelli, go ahead.
Thank you, Senator Lawrence. Representative Carlo, did you have a question?
I have no
Mr. Farber? Okay. Looks like Representative Foster does, however. And you need to unmute, sir.
I'm sorry, Senator. I don't have a further question for this.
Oh, okay. Just saw your hand still up. So seeing no further questions, Mr. Farber, thank you for being here today. And I understand that there are now Representative Foster has a question.
Thank you, Madam Chair. I do not have a question for the witness. I do have a question for the committee, and that is before you close this hearing, whether we feel it's appropriate for this committee to hear this bill, proposed legislation, or if it should be passed on to another committee, possibly judiciary. I raise that question because although if this committee were faced with a bill that were asking us to change regulation on the height of the high power line or how the payments were made in this settlement of this case or something along that line, I could see a case being made that this committee should hear this. But to me, no different than any other company that would be facing something like this, especially a utility, it would seem that it would be more appropriate for us to forward this on to judiciary. Thank you.
Senator Stewart.
Thank you, Madam Chair. This is, well, where it's a public hearing, we're getting into, I guess, a little bit of challenging territory here. I mean, I think it's a good question about jurisdiction. I will say that the title of the bill amends is 35A, which is directly in the purview of this committee. That said, but before the work session, we may want to consult with the Judiciary Committee about this or other similar efforts. But I think it's in terms of the referencing, it's accurate to send it here, at least to start. And then perhaps if the committee decides to do something else, we can do something later, but we'd reserve that for, I see Chair Barry has a comment that I agree with, it. We could probably take that up at work session.
Yes, thank you, Senator and Representative Berry. I agree. This seems like a discussion that should come back to the committee during work session. And I also understand from our clerk that in fact, we do have someone else wishing to speak in opposition to this proposal. If I got that message correctly. James Cody is with us. There he is. Go ahead, sir.
Thank you, Senator Vitelli, Representative Berry, and members of the committee. Hopefully everybody can hear me okay. I am James Cody here today on behalf of Versant Power in opposition, and I would say respectful opposition to LD 840. First, I'd just like to say, and I'll be very brief here, that on behalf of Versant Power, we'd obviously like to express sincere acknowledgement and sensitivity to the case that was described previously by Representative Carlo and Representative Berry. That is obviously a situation that I think any utility, be it gas or electric, would seek to avoid and mitigate well in advance. We don't oppose this legislation seeking to circumvent safety liability, but I think we oppose it more because safety liability or safety in general is paramount when anybody is working around these types of high voltage electric lines. And the premise behind the Overhead High Voltage Safety Act is that there is shared responsibility. There is shared responsibility by the utility and shared responsibility by any employer or employee that has their work being conducted within a certain distance of an overhead high voltage transmission line. LD 840 purports to modify the indemnification provision contained in the Act in such a way that would remove the financial liability for the employer or employee conducting the work on the overhead voltage line that is not a utility. And because of that, I think Mr. Farber did a good job of explaining that inadvertently disincentivizes anyone from doing that work by complying with the notice and safety provisions within the Overhead High Voltage Safety Act. So for those reasons, we respectfully oppose the legislation, and we would certainly be happy to participate in dialogue with both this committee and the Judiciary Committee, if that's ultimately where the Congress stands. And I would also just point out, as I read through the Act, if you go to Title 35A, Chapter 7, subsection 753, there's a section on duty and responsibility that really, I think, rightly describes sort of the shared responsibility by everyone involved in working in or around these high voltage transmission lines. Thank you very much, and I'd be happy to answer questions or bring information to the work session as you wish.
Thank you, Mr. Cody. Do members of the committee have questions? Representative Grohowski.
Thank you, Madam Chair. Thank you, Mr. Cody, for being here and speaking briefly. Would you be able to submit some written testimony to accompany your verbal testimony? And I would like to know Mr. Farber's testimony did just get resubmitted, so thank him for that if he's out in the ether still.
I suspect whatever the delay was with that testimony is the same with ours, so you should be receiving it anytime now.
Yeah, there is an instantaneous delay, but the system that we can see is pretty instantaneous. So I'll keep my eyes out for it, and you can go resubmit it when you're done here, please and thank you.
Sure.
My second question, if I may, was related to it. I'm having a senior moment, apparently. Somebody else, I hope, will have a question. Thank you.
Okay, we will come back to Representative Grohowski. Does anyone else have a question or a request for a work session regarding this bill? Trying to buy you some time here, Representative.
I'll just send a follow-up email, if that's all right.
Okay. Let me just check with the clerk to see if anyone else is in the waiting room.
Thank
you, Mr. Cody, for being here.
Sorry, that appears to be it for 8:40.
Okay. So just before we close out this work session hearing, does anyone have any questions that you want to bring to the work session? I think we've gotten a few. Okay. Then I think we're ready to close this public hearing, and we'll be moving on to the next bill, and somebody's going to need to tell me which one that is.
I believe it is LD 1328, which I'll present.
Very good. Okay. We will now open a public hearing on LD 1328, being presented by our very own Representative Seth Berry.
Wonderful. Thank you, Senator Vitelli, and again, fellow members of the committee. I'm here now to present LD 1328, which is an act to protect Maine electricity customers from threats of disconnection in the wintertime. LD 1328 would put an end to an unusual form of sanctioned lying, and I use that word quite intentionally, sanctioned lying, allowed under current laws and PUC rules. It would stop the persistent empty threats of disconnection that tens of thousands of Mainers have received all this past winter and in previous winters. These winter disconnection notices are a collections method, a coercive tactic that deliberately misrepresents the truth. They threaten to disconnect often low-income families, struggling seniors, and others in just a few days on a date specified in the notice during the dark and cold of winter. These empty threats were not this past winter being sent out in a vacuum. They were, in fact, pouring salt into a wound created by poverty, a pandemic, and a PUC dismissal of thousands of CMP billing disputes. Poverty is a major factor. Going without power is far easier for some of us than for others, and so is keeping up with bills. According to our own public advocate and a study they conducted in 2019, Maine's lowest income individuals currently spend $1 in every $4 they earn on energy. So if they earn $20,000, that would leave them about $15,000 for all other expenses. Imagine trying to live on that. So when threatened with disconnection, many of these individuals need to choose between food, medicine, heat, or power during the winter period in which disconnections are not allowed to begin with, but they don't know that. The pandemic has made this situation even more dire. Over the past year, frontline essential workers were left out of the enhanced unemployment benefits or PPP funding, yet stuck with new childcare, elder care, or other costs. Seniors working part-time, who I represent, were unable to supplement their meager Social Security income with a part-time job. They had to stay home to protect themselves or were laid off. So not all of us were able to work from home and enjoy a decent salary or wage during this pandemic winter. And on top of poverty and the pandemic, CMP's billing and metering mess made matters even worse this past winter. Thousands of CMP customers were informed by the PUC last summer that their disputed amounts would not be further investigated, despite hundreds of specific billing system errors in CMP's system that had been detected by our PUC, for which they were fined $10 million. These customers, thousands of them, were suddenly required to cough up thousands of dollars that they had been allowed previously to set aside. And I'm happy to go into my footnotes in my testimony regarding how this unfolded. I am very frustrated with the way that the PUC handled this situation. And we may or may not want to delve into that with this bill or another. Today, you will hear from just a handful of those impacted by this harsh treatment. Please keep in mind that for each of these stories, there are thousands of others like them. Most suffer in silence, too embarrassed or too proud or too busy surviving to ask for help. Now, to be very clear, the PUC does not allow winter disconnection, but they do allow threats of winter disconnection, including threats with specific dates on which the power will be shut off. I find that unconscionable. According to the PUC, in winter 2019, CMP issued, with the PUC's green light, 109,573 winter disconnection notices. Versant issued 66,884 notices. So together, over 175,000 winter disconnection notices in one winter. These notices come in the form of phone calls, letters, emails, even knocks on your door. And not surprisingly, they are most common in our lowest income areas. Washington County, where Versant and Eastern Maine Electric both reside and operate, is, I think, probably leading in terms of the number of disconnection notices being sent. And perhaps the PUC can help us to verify that. Today, you will hear both the Commission and the utilities, investor and consumer owned, argue that these empty threats somehow encourage customers to get help. While others I've spoken with, from customers to cap agencies, say empty threats hurt far more than they help. And besides, these empty threats are lies. And as such, they destroy the credibility of the utility, of the Public Utilities Commission, and by extension, all of us in the state legislature who allow it. They add stress, and they cause people to choose between food, medicine, or heat because they can't have all that and still pay down their arrearage on their utility bill. Even with our AMP program, you have to pay your current bill and the back balance. In a pandemic, when you're poor and when your arrearage, because of the winter disconnection, because of the disputes that have been summarily dismissed, are now due. So due to the global pandemic, the loss of income in some households, and the crippling impact of a PUC decision to dismiss thousands of billing disputes by CMP customers, many customers with balances over $3,000 and $4,000, this has been a terrible situation this past winter, especially bad. And bullying customers every winter with over 175,000 empty threats of winter disconnection is just not a good way to be a good neighbor, a good regulator, or a good corporate citizen. Thank you for listening. I ask that we close the door on these sorts of deceptive collections practices, and I'd be happy to answer any questions.
Thank you, Representative Berry. I believe there's a question from Representative Cuddy.
Thank you, Senator Vitelli, and thank you, Representative Berry, for putting this bill forward. I'm not sure I understood exactly what you were saying. It is not allowable for a utility to cut off power to somebody during the wintertime, but they are allowed to send out notices saying that they're going to cut off your power, even though they know they can't actually follow through on that. So somebody who isn't like sophisticated when it comes to our electric utility regulation would think that their power is going to get cut off, even though they have no money, they're out of work. They're still allowed to send that notice out, even though they know they can't do it.
That is roughly correct. So the PUC can allow winter disconnections if it chooses to do so, but it doesn't do it. So in effect, from November 15th to April 15th, there are no winter disconnections of residential customers. Now, a camp owner, down east in Versant or Eastern Maine Electric territory might often be disconnected. A business owner who has not paid their bill might often be disconnected in the winter months. Those things are allowable. But if you're a residential customer and you are sent a notice that says, and let's say it's January 15th, and Scott Cuddy receives a notice that from Central Maine Power, very official looking, warning, your power will be disconnected on January 28th if you do not contact us and make a payment now. And let's say you ignore it, then you get phone calls, then you get knocks on the door, or you get emails, all of these saying a very clear and specific date on which you will be disconnected. You will be disconnected, not might, but will be disconnected on that date. That is a lie. It is a deception that is used purely for collections purposes, and it besmirches the name of Central Maine Power or whatever utility is sending it out. I don't care if they're consumer owned or not. It besmirches the name of the PUC to allow this, and it besmirches the name of every legislator who allows this practice to continue. So I'm asking that we stop it.
Thank you very much, Representative Berry.
Senator Stewart?
Thank you, Madam Chair. And thanks, Representative, for putting the bill forward. And I agree that it seems like the system that my question is, because I recall I've had a number of conversations with both utilities, cap agencies, and others about this issue throughout the course of the pandemic and the implications that has. And it was my understanding that the PUC actually requires, to some extent, that disconnect orders actually go out after a certain amount of time, and will penalize the utilities if they don't send them, because of the fact that it will mess with the ratios of, how you stay solvent as a utility, which is equally important, because if the utilities go under, then we all have a problem. And so I think, can you clarify for me to what extent the utilities actually have to send some of these notices out? And, this isn't a loaded question. I legitimately.
It's a good question.
There's a process, and I'm not 100% familiar with it, but I recall hearing about the process that has to be used.
No, thank you, Senator. And it is a very good question. It's an important one, because the utilities are required to show that they have made efforts to recover bad debt, to get people to pay their bills. So, as an experiment, perhaps all of us should let ourselves get into arrears and see what happens next winter. Because what you will be told today by the utilities and by the commission is that somehow when you're in arrears and you call because you've been threatened with disconnection, you're going to get help. They're going to help you to connect with cap agencies. They're going to help you to connect with LIHEAP. They're going to help you to connect with the Lifeline program or AMP. And nothing could be further from the truth. The stories that I have heard from hundreds of Mainers, and you know what? They call me. They call me because somehow I got a reputation as someone who's willing to talk about this stuff. And the stories that I have heard from people who have been desperate and who have been threatened and who have not been helped in any way, shape, or form by the billing collections specialist, whose job is to bully and lie and deceive and extract payment, are horrifying. So, I fully agree. The question is a good one. There needs to be an effort by the utilities to work in good faith with customers, and yes, with our safety net programs, to get people help and to get people to pay. But this system that we have is broken, it is deceptive, it is bullying, and it is not working in any way to help those who are most in need. So thank you for that question.
Follow-up question, Senator Stewart?
Yeah, thank you, Madam Chair. Yeah, and I would agree that the system, I think, is what the problem is in this instance, right? So I'm on the board of a cap agency up here, and there's requirements that we can't even help people with things like LIHEAP or other avenues until they've actually received a notice that says you're going to be disconnected, even if it's not legitimate. But and I hear what you're saying in that regard. And Maine Housing too. And I hope that there are folks that are representing these people that are here today to share their opinions on the matter. Because I think, and my question is essentially this, right? That wouldn't it make more sense if this committee undertook an even greater effort to look at the whole system rather than just saying, well, you can't issue the disconnect notice? Because what I found is, particularly as you're dealing with these other institutions, that may have an unintended consequence of saying, well, now you can't access any federal money until you've received a disconnect notice. And then that may be even more troublesome for some low-income folks than, you know, in an attempt to try to actually help them. Oh crap, sorry, my phone's going off. Anyways, that was my question, I guess, is would you be interested in pursuing sort of a higher level reform to the way that the stuff works? Because I agree, it doesn't make any sense to me, right? Like, why do we have to issue a note? We know we're not going to get disconnected, and yet you can't access any federal funds until you've gotten the disconnect notice. And so it seems like we go around and around and around on this, and the very people who are trying to help end up getting hurt even more because of the way that the system is built. And I agree, I don't think that's right.
Thank you, Senator. You know, I could not agree more. What we need is a system that gives people a hand up, not a smack down. And right now we are smacking them down. So if this committee is willing to put in the time that it will take to start giving people that hand up and not a smack down, I am all about that. But right now, all this bill is going to do is prevent people from being lied to and bullied deceptively. So I would absolutely welcome that additional work, and thank you for suggesting it.
Okay, Representative Kessler has a question, but I want to ask if for your forbearance here for a moment. We have a co-sponsor of this bill, Senator Baldacci, who would like to speak but has to leave shortly. So if that's okay with you, we will come back to you, Representative Kessler, if that's okay. So we will bring in Senator Baldacci, who is a co-sponsor.
Good morning. I appreciate your flexibility, and I'm very proud to co-sponsor this bill. One of the things I want to give you a perspective from somebody who's north of Augusta. The second congressional district is one of the poorest districts in the country. It is one of the most rural. As an attorney for 29 years, I've represented thousands of people in many very difficult circumstances. I've, obviously traveled throughout the state. I'm a lifelong resident of this state. This bill is important to provide some level of a real safety net for people during the toughest months of the winter. We live in Maine, which is known for and many times we enjoy having a great winter. But when you are trying to make ends meet and you're supporting a family and the temperature is 0 degrees and everybody needs to be kept in safe and secure shelter, we need protection for there are hundreds of thousands of people in that situation during the winter in this state, particularly not just during a pandemic, which is only made it worse. So when I look at a public utility, I'm reminded that a public utility comes with serving also the public interest and serving some public functions. And I think that this is an important bill to help protect people who are living at the margins during the most difficult winter months. So that I've said my piece, and I look forward to working with everyone to get this passed. I thank Representative Berry for inviting me to co-sponsor this, and I appreciate everybody's time. Thank you.
Thank you, Senator Baldacci. Any questions? I know you have to jump off.
No, that's all right.
quickly,
I can say if there are any questions, I'll be happy
and
to.
Representative Kessler is first in line if you want to pose your question to Senator Baldacci, or you can wait and pose your question to Representative Berry.
Hi, I'm Chris Kessler. I represent District 32, which is the middle portion of South Portland and a little bit of Cape Elizabeth. And the question is for Representative Berry. So,
okay, thank you.
Okay, we'll come back to you then. Any questions for Senator Baldacci? Seeing none, we'll thank you for your testimony. And now we will go back and allow Representative Kessler to finish posing his question to Representative Berry before we go on to the next person.
thank you, Senator Vitelli. Good morning, Representative Berry. I wanted to ask the question about the assistance program piece, and I'm glad that you touched on that in the previous question. Might you be able to explain section 3 of the bill, where it says that the notice would be sufficient evidence to establish eligibility for emergency general assistance. How that would work mechanically.
Thank you very much, Representative Kessler, for the question. And I'm embarrassed to say I don't have the bill up in front of me. So let me get back to you on that for the work session. I don't want to shoot from the hip here.
Okay.
Follow-up question, are you all set? Okay. Any further questions for Representative Berry? Seeing none, I believe, thank you, Representative Berry, for bringing this. I believe we have Jane Overton next, who is going to be speaking in favor of LD 1328. Jane?
Are you able to hear me?
We can hear you, but we are not yet able to see you.
Okay. Start the video. Okay. Can you see
There
me
you
now?
are. Yes, please
Okay.
proceed.
All right. I'm speaking in support of LD 1328 because it would make it required for CMP to at least follow the protocols that are already in place for threats of disconnection in the wintertime, that they have to go to the Public Utilities Commission to ask for permission first before issuing a disconnection notice. Now, my experience with CMP, I don't think is unique at all. We pay our bills every month, but during the time in question, our bill went actually up by an order of magnitude, from $100 to like $1,100 in January of 2018. And I don't know why that happened. A little bit about our situation. We live in a barn that we're trying to remodel into a house. We do not have a hot water tank. We do not have a well pump. We pump our water by hand. We heat with wood. I cook on a hot plate. We really are not electric users for it to be $1,100 for a single month's service. So we're dealing with fraudulent charges to begin with. And then CMP has threatened to turn my electricity off 3 times during this winter. And I'm 70 years old and my ex-husband is 80 years old. The decisions to do these sorts of things are made by a Vanguard, which is located in Spain. And I am sure that a CEO in Madrid may intellectually know what the temperatures are in Maine in the wintertime, but I don't think they can know this on a visceral level, how things really are in Maine. You might be under 3 feet of snow and not able to get out. And the threat of disconnection that they can do from the home office through a smart meter really causes a lot of fear. I cannot imagine what it would be like being snowed in, 3 feet of snow on the ground, and the electricity being turned off, though we do try to prepare for that. And my bills really did go to $1,100 when we have literally no amenities, hardly. An electrician has looked at the panel, licensed contractor, CMP. Nobody can find anything wrong with our panel. Occasionally I lose appliances, just power surges, but we both have health issues. And if this legislation requires CMP to actually do their homework and go to the PUC for permission and show cause, I think that would be more reasonable. And maybe they would offer me a more reasonable payment plan, though I am a part of a class action suit. And the PUC
to wrap up, please.
Oh, I'm sorry. It will remove the threat of their ability to threaten to disconnect without the legal right to do so. And I think that's a very simple thing. And so this bill should go forward that way. And that's really all I have to say.
I appreciate your testimony.
Yeah, what to do about fraudulent charges is, it's not always about poverty, though I'm on Social Security and I am poor. But it's, but I pay the bills, and it just the set aside was $1,500. But the fraudulent charges have not been addressed yet, and are not being addressed by the PUC. So until we get judicial relief, they shouldn't be allowed to disconnect in any season of the year. But they certainly shouldn't be allowed to disconnect without going through the steps they must do by protocol with the PUC.
Thank you very much. Are there questions for Ms. Overton? Seeing none, thank you for being with us today and sharing your story. I believe next we have Ronald Gordon to speak in favor. Can you?
Okay. My name's Ron Gordon Jr. I represent my mother, Margaret Gordon, which is legally blind, and these disconnect notices that she gets in the mail just keeps her upset. It keeps me and my wife upset, and we're just getting fed up with them because every time we try to make a payment arrangement, they lie to us. They want more money than she can actually afford. So, you know, we're in a bind. We don't know what to do with it. The threatening is getting tiring. They hear it and see it in paper. So we just don't know what to do. You know, it's very hard for us to keep the bills paid up.
Thank you, Mr. Gordon, for sharing that story. Are there any questions for Mr. Gordon? Seeing none, we appreciate you taking the time to be with us here today.
Thank you.
And I believe next we have Joby Thoilo. I'm sorry if I'm not pronouncing your name correctly, and I should know it by now.
You got it right. It's Joby Thoilo.
Okay, thank you. Please go ahead and tell us your name and who you are and your thoughts on this bill.
Thank you very much. Good morning, Senator Vitelli, Representative Berry, and members of the Joint Standing Committee on Energy, Utilities, and Technology. Again, my name is Joby Thoilo. I'm a senior policy advocate at Maine Equal Justice, which is a nonprofit legal aid organization working to increase economic security, opportunity, and equity for people in Maine. I'm testifying in support of LD 1328. Current regulations provide, and I know Representative Berry went through much of this, but the current regulations do allow notices to go out, but however, disconnections are not actually allowed without special permission from the Public Utilities Commission. And so when a notice goes out indicating that a disconnection is going to occur, that they're not actually at that stage yet. What this bill simply does is say, you can't say you're going to disconnect until you get that special permission from the PUC, which will then make the notice honest. And until then, these notices are very easily misunderstood, and they cause a lot of fear. And that is the main reason why we support this bill, which to us seems like a simple fix. I mean, most of the examples we've seen of these disconnection notices, they give the impression that the customer must pay or they will lose service, even though the utility has not obtained the authority yet. And even though that the customer has the opportunity to contest any disconnection of service before that occurs. This would be stressful for anyone, but for a family struggling to pay their bills, it could mean the difference between having to make a choice between heating their home during the Maine winter and adequately feeding their children. People in poverty actually have to make hard choices like this far too often, but they shouldn't feel the need to do so when it's based on misleading information, which is the case with these disconnection notices. In the case of someone who relies on life-sustaining equipment, such as a ventilator or an oxygen pump, the fear caused by such a notice is only that much more intense. Generally speaking, people living near or in poverty and who struggle to afford their bills live under chronic stress that impacts their health, their life outcomes, and their ability to get out of poverty. The last thing someone in poverty needs is to be misled by the threat of immediate termination of their electricity service. Many people with lower incomes depend on stringing together multiple low-wage jobs and just to make ends meet. And the reality is that those jobs don't provide consistent income all year round. A misleading disconnection notice in November could lead to a family unnecessarily making the hard decision to forego one basic need for another, when the same family may be getting a tax refund in January that would allow them to catch up on that bill. Again, we think this bill is a common sense solution that requires utility providers to communicate clearly to their customers. It's a simple fix that could prevent unnecessary stress and harm to those struggling the most to get by in our state. I just wanted to add, I wanted to address something that Senator Stewart brought up earlier, which I know that, and then Representative Kessler also referred to. I know that Section 3 of the bill is trying to account for the fact that currently certain assistance programs do use these disconnection notices as sort of proof that you're in an emergency and therefore eligible for that program. And Section 3 addresses that issue for general assistance and I believe LIHEAP. It looks like the fuel assistance program, which I can confirm in time for the work session, but I believe that's LIHEAP, and I'm sure the committee analyst would be able to confirm that.
Great, thank you.
And I guess I'll just say also, sorry, I just wanted to also address Senator Stewart's question about LIHEAP is federally funded. As far as any other federal assistance programs, I know I worked on this testimony and analyzing the bill with our litigation director who's worked on that policy for decades now, and he didn't have any such concerns, but I can double check with him in time for the work session as well.
Thank you
so
for
I'll conclude by
clarifying
just
that.
saying, really hope that, sure, and yeah, happy to answer any questions you might have.
Thank you very much. Are there any questions for Joby? I think you already answered some of them, so thank you for that. And perhaps you'll join us for the work session.
Thank you.
And now I think we're going on to Les Fossil, who is also here to speak in favor of the bill.
Thank you. Can you hear me?
We can hear you and we can see you, so go right ahead, please, sir.
Senator Vitelli, Representative Berry, and distinguished members of the Energy, Utilities, and Technology Committee. Thank you for this opportunity to testify. My name is Les Fossil, and I'm a recovering state legislator. Since I did not serve on your committee, I have no gifts for you other than my words. I am here to testify in support of LD 1328, an act to protect electric customers from threats of disconnection in the wintertime. As many of you know, I have decades of leadership experience as a Republican in Maine politics. I served on 5 standing committees in 124th and 125th legislatures. I co-chaired the Moderate Caucus, which was then the largest in the legislature. Attached is a series of emails that describes what brings me here to testify. As some of you know, I have an award-winning contracting business in Maine for the last 40 years. Currently, we have 16 employees and a year's backlog of contracted work. Unlike many other Maine businesses, the COVID pandemic has doubled our business. Like many small businesses, however, we have one commercial account with CMP that covers both our business and residents. We have stayed in business for 40 years because we pay our bills on time and in full. Imagine my shock when on February 10th, we received a phone call from CMP saying they would disconnect our electricity if we did not immediately pay our bill. My wife, not having access to our checking account, arranged a payment plan. In fact, our CMP bill was not delinquent, according to CMP's own website. We had received no notification in any form that our bill was delinquent. Not surprising, since it wasn't delinquent. At that time, we had over $100,000 in our checking account. I suggest a couple of amendments to your bill. First, that CMP send a registered letter, return receipt requested, before they cut off any customer. If this were done, then there would be evidence that a customer was notified. It would not be a he said, she said. Two, that all business accounts that also cover residents be protected from wintertime disconnection. And three, that to protect our economy for those who have not benefited from COVID, that all disconnections be suspended until the end of the COVID crisis. Since CMP has proved to be an unreliable energy supplier, my solution is we're going to install enough solar panels to fully supply our electric needs so we never have to rely on them again. And I've attached 2 emails from my office manager. And the substance is, yes, I'm looking at the CMP bill. This is February 10th, the day they threatened to cut us off when it was, I think, 8 degrees. Yes, I'm looking at the CMP bill on the website. This disconnect notice is a mistake. Even they say they are not sending any out right now. There is nothing outstanding in that range. And then a few minutes later, or a few minutes before, I sent them a balance in full check on the 31st of December. I have not seen the January bill yet. They also have our December payment posted in their system. I'm not sure what is going on with them, but everything online is in order, albeit January was due today, nothing like 3 months later. I'd be happy to answer any questions, and I suspect you can understand my frustration. Thank you. And this is my wife in the background who had to take the awful call.
Thank you very much, Mr. Fossil, for being with us today and for your testimony and for your wife's presence. Are there questions for Mr. Fossil? Seeing none, we appreciate you being here with us today and wish you good luck in all your works.
Yep.
I didn't know that people actually did recover from being legislators, but it's good to know.
Well, there's a 12-step program involved, and there may be a relapse. You may see my crazy face in the next session. Who knows?
Okay, thank you very much. We'll keep an eye out.
Good.
So I believe we have a couple more folks to speak in favor, and then we'll shift over to those speaking against or neither for nor against. And up next is it Chuck Piper. There he is. Mr. Piper, can you join us? Are you still there?
Can you hear me?
Now we can hear you, yes.
Oh, great. Thank you for calling on me. I had actually registered for LD 1100.
So did you want to speak in favor of this bill or not?
I'm in favor of it, but that's not my reason for being on today.
Okay, so perhaps we'll come back to you later on in today's session.
1100. How can I clarify that so you'll call me then?
I think Jordan, our committee clerk, can contact you.
Yep, I've made note of it.
Yep,
okay, thank you.
Okay, we'll check in with you later on.
Thank you.
So with that, Jordan, who is next in line then?
Julie Marie is next.
June Marie is here to speak in favor. There you are. Oh, Julie Marie, there you are. Go ahead, please.
Good morning, Senator Vitelli and Representative Barry and members of the Energy, Utilities, and Technology Committee. My name is Julie Marie Bickford, and I'm speaking today in my capacity as Executive Director of the Maine Dairy Industry Association, a trade group known as MDIA that represents all of the Maine cow dairy farms who are shipping milk for human consumption. Most of our farm families are also very active in their communities as small business people, employers, and active as residents of their communities. Our dairy farmers have a national reputation for producing high quality, nutritious milk. We take food safety and animal welfare very seriously. And there are two items that are critically important to the operation of a dairy farm. One is hot water in order to sterilize all your equipment and keep everything safe and clean. The other is electricity. Electricity is used to run the milking equipment. In some cases, it is used to create hot water. It's used to provide the necessary energy to operate the chilling tanks that keep the milk at optimum temperature once it has been collected, as well as to run the fans that ensure the cow's comfort, especially during hot and humid weather. The reason I am speaking today is because I have had one farm in particular, but there have been several who have experienced these disconnection, repeated disconnection communications from CMP in the form of almost a type of, it's been a very negative dynamic. Instead of working with these small business people who very often the farm and the home are connected, there has been an adversarial relationship, unfortunately, that has developed. And it's very troubling, not only from the aspect that, again, very often the residence is connected to the farm. And so you're jeopardizing not only somebody's home, but you're also jeopardizing their livelihood. And it's a vicious cycle. If they can't earn a living, they can't pay a bill. Is the bill, is it a legitimate disconnection? There are a lot of questions. And so this bill has caught our attention, and we very much would like to see some advice coming from the committee to CMP as to how maybe to better build relationships with their customers, but also in using this kind of tactic, that it be used more judiciously. And when there is the actual authority for disconnect, rather than as a heavy-handed mechanism just to try to increase their accounts payable. On a personal note, I will admit I have had a similar experience to former Representative Fossil, in that I have, in my own residence, received several of these calls threatening disconnection for an account that was not delinquent, did not meet the criteria during the winter months. And to the point where basically my standard operating procedure within the home is that if the caller ID shows that it is CMP, I do not take the call, because it has become a nuisance. And so, I have that personal experience with this situation. So I appreciate your consideration of this bill and hope that you may be able to encourage this particular entity to operate in a manner that is more amenable to the hardworking people of the state of Maine. Thank you.
Thank you very much, Julie Marie. Are there questions for Ms. Bickford? Seeing none, we appreciate you being here with us today. Thank you for your testimony.
Thank you
for speaking up for the cows. I believe now we're going to be switching to those who are testifying in opposition to this bill. And the first person on the list, I believe, is Deborah Hart. And there she is. Go ahead, please.
Can you hear me?
Yes.
Great.
You
Thank
said
you.
it again.
Sorry. I did say it again, and I told myself I wasn't going to say it again today. Good morning, Senator Vitelli, Representative Berry, and members of the Energy, Utilities, and Technology Committee. My name is Deborah Hart. I'm a resident of Manchester, Maine. I own Hart Public Policy, and I'm speaking to you today in opposition to LD 1328 on behalf of my client, the Derigo Electric Cooperative Companies, which are your consumer-owned utilities. I am not going to read my testimony to you. I have outlined the process that they follow under Chapter 815. I have a feeling that the PUC will guide you through that process, what they can and cannot do, and the timing of what they can and cannot do. So it's all in my testimony. With all due respect, we do feel that establishing contact with a customer is an important part of getting them to either be able to pay their bill, guide them to what else they can do, if they need to be put on a payment arrangement, if there's some way that we can get them assistance so that they can pay. But just not doing anything just makes that bill grow exponentially, and that's not good for the utility. And we don't think it's good for the consumer, because they then end up after that period of time, after the disconnection period, with a very large bill that they then have very little opportunity to make up. So I have talked to my clients. They do send disconnection notices. They send them under the process that's outlined again in 815. What I am told is they will call the customer. They will try to make contact. They will try to see if they can assist them so that they can pay the bill. What they do not do is say, you will be disconnected if you don't pay this bill. So I think that there is a difference from what we're being told, that some people have what their procedure is. That's not the procedure that I'm hearing from the people that I represent. Lastly, I think that you heard from Senator Stewart that possibly there's something broken here. And it occurs to me, and I'm speaking on my own part, not for my clients, but if the only way you can get somebody's attention is to put them in an uncomfortable position, that's not what I hear from my clients that they're trying to do. But if that's the way it's being perceived, then maybe we need to fix that process. Maybe we need to look again at how you get to that assistance piece before somebody feels like they're going to be put in a very disadvantaged situation. So I will stop with that. Again, we'd be more than happy to work with this committee if there's a way for us to all coalesce and try to see if we can fix this system so that everybody's in a better position. And I will stop with that.
Thank you very much, Ms. Hart. I saw Representative Cuddy's hand up, and then we'll get to Representative Berry. Okay. Representative Cuddy, questions?
Thank you for the testimony, Ms. Hart. So do your clients not send a disconnect notice during the time when it's typically prohibited for residential customers? Is that what you're saying?
No, I'm saying that they do send a disconnect notice. What they do not do, I am told, is they do not follow up with that phone call that says, you either do this or you will be disconnected. They don't do that with a phone call. They do send the disconnect notice. They do it under the rules of 815, which I think the PUC is going to outline for you. There's a process where they have to get in touch with the PUC. The PUC says, okay, yes, you can do this. And that's the process that they follow. If I wasn't clear in that, I apologize.
That's okay. It's quite possible you were. My head begins to start swimming after the first hour and a half, 2 hours of testimony. So I like to make sure. Thank you.
Okay, thank you.
Thank you. Representative Berry, did you have a question?
I did. Thank you, Ms. Hart, for your testimony. And it just relates to what was just being discussed. So what we're seeing on the part of the larger investor-owned utilities is giving a specific date. So it's January 13th, and you receive a notice on your door, you receive phone calls, you receive emails, and you receive written letters, and they specify a certain date. It's January 15th, and you received all of these notices, and they say you will be disconnected on January 28th. That date is the deception, is part of the deception, because it's there is no permission, and there is never permission for a residential customer to be disconnected during the winter months. Am I hearing you correctly that your clients do not use that specific date threat in these ways?
I believe, and I will follow up because I don't want to mislead you. I believe that there is a date specific. It's not open-ended. It says by this date, But you still have to receive permission from the PUC, and they don't disconnect during the winter time. What I was trying to say was they don't call you and say, you're going to be disconnected on X date. They go through the paper process, again, with the idea that they're trying to get people's attention that this is something you have to pay attention to. And so let's either figure out a payment arrangement or get you the help that you need if they haven't applied for assistance. And I don't know at what point you can get assistance if you haven't gotten the disconnect notice. For some reason, that's a little unknown to me, but there seems to be a period of time where you have to do something in order to get the assistance.
Senator Vitelli, may I ask a follow-up?
Yes, you may.
Thank you. Ms. Hart, just for the work session, could you perhaps collect us a few random samples of winter disconnection notices?
I will do that.
And I'll ask that of the other utilities as well. Thank you very much.
Okay.
Further questions for Ms. Hart? Seeing none, thank you for being with us again today.
Thank you.
I believe next we have speaking in opposition is Linda Ball. Linda, go ahead, please.
Good morning. Good morning, Senator Vitelli, Representative Barry, and members of the Joint Standing Committee. My name is Linda Ball. I'm the Vice President of Customer Service for Central Maine Power Company, and I am speaking in opposition to LD 1328. Chapter 15, we've heard this morning, protects the vast majority of residential customers from being disconnected in the wintertime because we cannot disconnect residential customers without explicit permission from the CAD. To be clear, CMP has not requested permission to disconnect any residential customers this past winter or in fact the winter before either. At the same time, sending disconnection notices in the wintertime is a critical step to keeping customers informed about the status of their account. It does encourage customers to make payment if they can make that payment. For customers who can't make the payment, it may encourage them to seek assistance and get help that is available. It also encourages customers to call the company and make payment arrangements. And sometimes that is a prompt the customers need. I appreciate that customers are proud and it is a challenging situation when they can't afford to pay their bills. What I don't think is optimal for customers is to not be told that the bill is past due. I think that's really important, and it may encourage them to have that hard conversation that says, here's what I can pay, and here's how I can keep my service intact, and then not have any risk of disconnection. As one person mentioned earlier, they may be getting a stimulus check or a tax return or a big check in 2 weeks. What the disconnection notice may encourage them to do is simply call and tell the company that I can't pay you this week. I can pay you in 2 weeks. Or I can pay an extra $50 a month on top of my regular bill. The other thing I want to point out is that the disconnection notice includes a lot of really important information. It tells customers what their past due balance is. It tells them what their total account balance is. And it also gives good information that says, if you can't pay your bill, please call us and set up an affordable payment arrangement. It also says you may qualify for assistance. And without that notice, I don't know if customers are going to be aware of those assistance paths. On the entire back of the bill, it talks about 211. It talks about low-income home energy assistance programs. It talks about ELP, which is another grant program. It talks about the oxygen ventilator benefit, which provides credits to customers' accounts. And it talks about the AMP program, in addition to talking about medical emergencies for people who do have medical equipment in their household, and it tells them how to protect their service. And it also gives critical contact information for the CAD if there is a billing dispute. I do want to talk for a minute about the phone calls that customers receive. Those phone calls happen if we haven't heard from a customer and there's a disconnection notice that hasn't been paid, and that is the company trying to reach them to make sure they know about the status of their account. I will say those phone numbers are in the system and they're dialed automatically. We do have episodes where a customer changes their phone number, and now the phone number we're dialing to reach Jane suddenly belongs to Martha, and Martha doesn't owe a past due bill. If Martha doesn't answer the phone and tell us that that's not her phone number any longer, we don't have a way of knowing that. So I would always encourage people to call the company. Call the company if you think you've paid the bill and we don't have a record of it. It could be lost in the mail. It could not be applied to your account. There could be a problem with the check. I don't know if customers don't talk to us, and everything about a disconnect notice is to encourage customers to talk with the company and manage the amount that they owe. That doesn't mean paying in full. We completely recognize that not every customer can pay their past due balance, but I do think it means they should talk to us and make arrangements that they can afford to stick with or get assistance. There's a lot of help out there, and the disconnection notice tells you what some of that help is and encourages you to apply for it, or at least encourages you to call us and tell us what the situation is. Thank you.
Thank you very much for being with us today, Ms. Ball. Are there questions? I see Representative Cuddy. There you go.
I thought I hit the unmute button first, but I was a little ahead of myself. Thank you, Senator, and thank you for your testimony, Ms. Ball. I don't have your written testimony, so I'm going based on memory of what you said. You were talking about contacting a customer to let them know where their account stands. So I'm interested in the process that CMP uses to let people know about their bills and where they stand, because the idea that you want to let them know that their bill is overdue and these are the options they have is a very different thing than letting them know that their account is overdue and that there's a date certain at which they will be disconnected, when CMP must know that during this period, the PUC doesn't allow residential customers to be disconnected. And that is a big part, I think, of what we're being asked to get at here. So can you tell me the process that CMP uses to let people know you're overdue, these are the options you have, and then you're going to be disconnected even though you can't be disconnected at this point?
Sure, and I appreciate the question. Thank you. If a bill isn't paid, we do send what's labeled a disconnection notice, and that is in accordance with Chapter 815. The disconnection notice has a line that says potential disconnection date, and it does have a date on it. It has the word potential. And then it has an asterisk, which goes to a line that says, with permission from the Maine Public Utilities Commission, your service could be disconnected on this date or within a certain number of days of that date. In the wintertime, that's 20 days for a residential customer. So it is labeled disconnection notice, but there are disclaimers on there that say it's only with permission from the Maine Public Utilities Commission, and the word potential is there. If a customer doesn't talk with the company by the expiration date of that notice, we do make the outbound phone calls, and we typically are going to make a day call and then a nighttime call, which is after 5 p.m. and then sometimes a makeup call if we haven't been able to reach the customer. If we still haven't spoken with the customer, either because we've called them or because they've called us, we do send a field worker to the house, and they deliver a package of information, which includes not only a notification that the bill is past due, but also information on the assistance programs that are available, including a list of all of the CAP agencies and phone numbers and addresses to apply for that help.
Thank you.
Question, are you all set? Okay. Further questions for Ms. Ball? Seeing none, thank you for being with us today and for your testimony.
Thank you.
I believe we are now going to be switching to neither for nor against, and we have with us Barry Hobbins.
Good morning.
Okay, we can hear you, but can't see you yet, Barry. There we are.
Good morning.
No, you've disappeared again.
Can you hear me now, as I say?
We can hear and see you. Go right ahead.
Thanks. Thank you very much. Good morning, Senator Vitelli, Representative Barry, members of the Energy, Utilities and Technology Committee. My name is Barry Hobbins, and I am here to speak neither for nor against the bill. Now, you're probably asking yourself, why wouldn't the public advocate be speaking for the bill? It's not a question of being for this bill. It's a question that disconnect notices are only the symptom at the end of the problem. And we can all feel good about doing something about disconnection notices, but it goes beyond that. We have to look at other programs such as the Arrearage Management Program, which is fighting to even become a permanent program by the legislature. Because the primary goals of a program such as an AMP program is it provides a pathway to avoid these disconnection notices. It helps to reduce bad debt, collection costs, and disconnection costs. Efficiency Maine Trust does an excellent job through their targeted intervention about low-income individuals in the direct relationship between someone's ability to pay and being low income and, unfortunately, the heavier use of electricity. The reason I mention this is that there is a lot more to do than what occurred as a result of the $500,000 penalty with Central Maine Power Company neither admitting nor denying their effective program, or not a very effective program of disconnection. And really what Senator Barry has said, unfortunately, was really partly the case. I won't say it's all the case. I don't have all the facts, but I can tell you it is part of the case. My suggestion is that we use this bill as a vehicle to go beyond what the intention is of getting rid of a disconnection notice, because that's maybe a feel-good issue, but it's not the issue. What we need to do is address some of the concerns we've heard, and the Office of the Public Advocate would suggest a conversation during a work session or many work sessions about the current Chapter 18 rule and see if there's something that can be addressed through rulemaking and not in the statute. In this, is there a way, for example, to keep this tool available as an absolute last resort? And maybe it requires some type of rule or law that would require a second or third pass-through notice be sent before allowing them to even start the disconnection process. Now, as an immediate issue, what this committee could do is write a letter to our investment-owned utilities, and even the COU utilities, asking them to not to start an onslaught of disconnection notices that will hit on April 15th. I believe that many states have delayed the disconnection process or notice process until this covert is at least under control. And I know that it's not just the date, but remember, individuals have not been educated about this whole situation. And what I hope the Public Utilities Commission can do is take some of that $500,000 that goes into the black box and use some of it to do some educational outreach with the cooperation of the utilities, Efficiency Maine, and of course, the Office of the Public Advocate. That money could be utilized in a very positive way to start educating individuals to address the arrearage management issues that are a small token attempt, but a very, very wise attempt to try to alleviate the present problem. If you have any questions, I'd be more than happy to answer them. But please understand, my stating neither for nor against is not endorsing the past issues. our office was extremely aggressive in our approach against Central Maine Power Company and representing the interests of low-income ratepayers.
Thank you very much, Mr. Hobbins, for your testimony. Are there any questions for Mr. Hobbins? Seeing none,
Thank you.
thank you for being with us. I believe Garrett Corbin is next, also speaking neither for nor against. Garrett?
Yes, good
Good
morning,
morning.
Senator Vitelli and Representative Berry, honorable members of the Committee on Energy, Utilities, and Technology. It's nice to see you this morning. My name is Garrett Corbin, and I'm testifying neither for nor against LD 1328 on behalf of the Maine Public Utilities Commission. To start with some background on our rule, Chapter 815, which has been mentioned this morning. That rule sets forth the general policy considerations regarding winter disconnection. The first policy is that customers should not be disconnected because of their inability to pay their utility bills during winter months when severe weather conditions can pose a threat to health and safety. The second policy is that electric and gas utilities should attempt to contact all customers who are in arrears by more than $50 and establish a regular or special payment arrangement. The third policy is that the customer should pay a reasonable portion of each monthly bill during the winter period to avoid significantly increasing their arrearage. These policies are intended to strike a balance between the protection of the health and safety of residential customers and the ability of utilities to collect amounts due for service to these customers, consistent with the statute enacted by the legislature. It's important for the committee to know that these policies were developed through a rulemaking proceeding that established Chapter 815 in 2008. In that proceeding, the commission created a working group. The group was comprised of low-income advocates, utilities, the Office of the Public Advocate, and commission staff, and it examined winter disconnection processes and trying to explore the possibility of establishing a moratorium on disconnections during the winter months. The general consensus of that working group was that a complete moratorium on winter disconnections would be harmful to customers. That's because customers would not be able to access financial assistance through social services without an imminent threat of disconnection, and because the possibility of a winter disconnection provides customers some motivation to make whatever payments are possible, thereby reducing the arrearages those customers might have otherwise acquired. Stakeholder parties agreed that this would ultimately result in a reduced likelihood that these customers will lose their electric or gas service at the end of the winter period. The purpose of a disconnection notice is to solicit contact with a customer who is having payment problems. In fact, the vast majority of disconnect notices result in payment or in an arrangement to pay, resolving the matter without the need for involving the PUC. Due to the sheer volume of disconnection notices issued, it would be prohibitive from an internal commission resources standpoint for our CAD division, Consumer Assistance and Safety, to pre-approve each of these situations prior to the utility issuing a disconnection notice. Second, as discussed earlier in reference to Senator Stewart's question, before the issuance of a disconnection notice and the resulting imminent threat of disconnection opens the door for financial assistance to customers that would not exist absent the active disconnection notice. For example, a customer who has an active disconnection notice and qualifies for LIHEAP is able to access assistance through the Energy Crisis Intervention Program, ECHIP, administered through LIHEAP. And customers who qualify are also eligible to receive assistance from the Emergency Assistance Program, EAP, administered by DHHS. The assistance provided by these programs are often sufficient to cure the disconnection situation, avoiding the need for the utility to seek PUC permission to disconnect. Finally, the Commission's CAD division, as a general policy, does not provide permission to utilities to disconnect customers during the winter months. Instead, the CAD attempts to connect with the customer and establishes an affordable payment arrangement to ensure that the customer does not lose their electric service. In light of this objective, the CAD would not be inclined to pre-approve a disconnection request submitted by a utility that more likely than not would be resolved without the need for disconnection. That's one of the requirements of the bill. Further, this requirement could have the unintended consequence of an actual disconnection taking place during the winter months due to the pre-approval process in situations where a customer fails to respond to the disconnection notice issued by the utility. And lastly, just to try to help answer Representative Kessler's question before, the proposed section 717 subsection 3 in the bill states that a disconnection notice to a residential customer from an electric utility for a past due account that, if not paid, could lead to a termination of utility service that's issued after April 15th is sufficient evidence to establish eligibility for emergency general assistance as described in law. The Commission's knowledge, many customers who receive a disconnection notice are not low income, and the vast majority of these customers ultimately pay their bill. For example, in 2019, I've got some data, some figures in our testimony, but that show that most customers pay or enter a payment arrangement when they receive a disconnection notice. The Commission also observes that this requirement might conflict with income eligibility requirements for general assistance and fuel assistance that we described before. Hope that information is useful. We certainly welcome any questions.
Thank you, Mr. Corbin. Are there questions from the committee? Seeing none, we appreciate you being here with us today. And I believe our final individual to testify neither for nor against is now with us, James Cody. Go ahead, please.
Good morning again, members of the area and members of the committee. Again, I'm James Cody on behalf of Versant Power. Versant Power testifies neither for nor against this legislation today, but I would like to point out that as we discussed this legislation, we thought a lot about the points that Ms. Hart and Ms. Ball, as well as the PUC and the OPA brought up to you, in that disconnection notices do serve an important purpose. But we also wanted to relay that we understand that things can always be improved, and we're certainly happy to be part of a dialogue to improve those things that achieve benefits for all customers, as well as the utilities and other stakeholders as well, including the Public Utilities Commission. So with that in mind, I would just like to say I hadn't thought about Senator Stewart's suggestion, but it seems like in 2008 that a stakeholder group got together to improve the way in which these winter disconnect notice processes take place. And it seems as though that we may be in a position where we want to discuss that again, and Versant Power would be more than happy to participate in that dialogue. With that said, I'd be happy to answer any questions. And I know Representative Berry made a request about a sampling of disconnection notices, and we'd be happy to provide that for the work session.
Great, thank you very much. Are there questions for Mr. Cody? Seeing none, I believe this ends our testimony on this bill 1328. Before we close this hearing, I just want to check with both our analysts and double check with our clerk to make sure nobody else got in the room at the very end, and see if we're in line to move on to the work session on this particular bill. Deidre, there were a couple things people asked for. Did you?
Yeah, I got what people asked for. Yeah.
Okay, so you think we're all set there? And Jordan, nobody else is in the room?
No, there were a couple other people who were signed up to testify, but none of them are currently on the Zoom. So I think that's it for this bill.
Okay, thank you. So with that, I will close this public hearing on LD 1328. And at this point would ask the committee if this is the moment in which we want to take a break. I think we skipped over our morning break. And I believe the next bill that's up is, 1079, which is, I believe.
Mine, Madam Chair. So I'm happy to take a pause here if you'd like before presenting it. That makes sense to me.
Okay. Any objection? I'm going to actually have to shift over to a different committee, so this timing could work well, and we'll turn the gavel back to the co-chair, Representative Berry, to take on the hearing for Senator Stewart's bill.
That's fine. Thank you very much, Senator.
11:45 sound right for people, or?
That sounds perfect. And if I may, I just want to give folks a rough sense of what the day looks like afterwards for those who are listening in and planning to testify. I think after this break until 11:45, we will hear 1079 and 1116. We'll try to get through both of those and then take a late lunch. So have a snack now, please. We'll then have lunch and come back for the remaining bills, 1332, 1025, and 1100. Does that sound about right? Senator Patelli, others? Any objections?
Sounds like it'll work.
Great. And I don't know which senator will be chairing for my bills, but I'm sure there will be one to do so. One of you can take the gavel during the two bills that I have to present later on in the afternoon.
We'll
So with
figure it
that,
out.
great. See you at 11:45. If you could turn off your video and audio, that would be great. Okay, it's 11:46, so folks could turn on their video again. That would be great. Okay, and welcome back to the Energy Utilities Technology Committee. We've done introductions and all the preliminaries, so we'll jump in right into our next hearing, which will be on LD 1079, and that will be presented by our very own Senator Stewart. Senator, take it away.
All right. Well, we're still in morning, so good morning. Senator Lawrence is not here. Representative Barry and members of the Energy Utilities and Technology Committee. As you know, I'm Trey Stewart, State Senator in District 2, 51 communities in Aroostook and Penobscot counties. And I'm here today to present testimony on LD 1079, a resolve to review the effects of the deregulation of Maine utilities. I should note too that the subsequent bill to this is 1116. The two are very similar. So if it sounds like I'm sort of repeating myself, that's because I am. So through this resolve, the Public Utilities Commission would be tasked with establishing a commission to review the impacts of policies enacted by lawmakers which deal with the restructuring and deregulation of Maine's electric utilities. I would personally like to see the commission specifically analyze goals of the restructuring effort that previously took place back in, well, from 1997 to 2000. And the effect of restructuring on grid reliability and stability, impacts to the ratepayers, and how the undertaking of the effort to decarbonize Maine's electrical grid will impact Maine over the next 30 years. In doing so, this committee, upon the report back of the commission, which would be dated December 1st of this year, will gain a greater understanding of how the policies that we enact directly impact consumers, as well as the best way forward in restructuring Maine's electric industry if the committee decides to do anything in that regard. So 20 years ago, this committee and the legislature made a substantial change regarding energy policy when they restructured the relationship between the generators and the utilities. At the time, there were obviously several goals that the legislature hoped to accomplish. And I think it's worth reflecting on whether those goals were met or not, and what, if any, changes should be made to either what those goals are now or how those goals are achieved. Almost everything we do regarding energy policy in Maine is impacted by this decision made 2 decades ago. It's worth reviewing the impact that legislation had to ensure that we are still on the right path and how we move forward with the goals and policy that this committee and the legislature puts forward. I think we can all agree that it is a good thing when policymakers and the public are aware of the impact of previous policies had, and what successes and missteps those policies might have had. I believe the commission's findings would help us to discover ways to best provide that information for us now and going forward as we look at the next generation of energy policy in Maine. Thank you for your time and consideration. Happy to answer any questions the committee might have at this time. I believe that you're muted.
I seem to have, I thought I was unmuting, and evidently I was muting myself. Are there any questions for Senator Stewart? All right, seeing none, are there any co-sponsors? Oh, I'm sorry, Representative Foster, didn't see you there.
Thank you, Mr. Chair. Thank you, Senator Stewart, for your testimony and presenting this bill. I guess I would just comment, some say we can never go back again, but I think it's a worthwhile opportunity you've presented here to look at the ramifications of what was done in the past. I'm wondering if you know how many other states, I know several that have undergone deregulation of their electric utilities and generation facilities. I'm wondering if you know how many states there are that have still, though not undergone deregulation, and that's something we might want to discuss more at the work session. But if you have that number, I'd be interested in that. Thank you.
Thanks for the question, Representative. I don't have that number off the top of my head. There may be somebody testifying behind me today that might be able to answer that question. Certainly, we can try to get that for you for the work session, though.
Excellent. Any other questions for the sponsor? Seeing none, are there any co-sponsors wishing to testify? And Jordan, we don't know of any, is that correct?
I don't believe anyone else is on or is interested in testifying.
Okay. Well, that will bring us to other testimony in support. And first up is Mr. Stephen Hudson.
Thank you, Mr. Chairman. Representative Barry, members of the committee, my name is Stephen Hudson. I will first start off by saying that my written testimony was uploaded late. So Representative Grochowski may not have it yet, but I can assure you it's in the system. It's also been submitted. It's the same piece of legislation for both of Senator Stewart's bills. So you can find it in both places. Oh, she says she has it. Thank you. I am not Tony Buxton, however, but I am a partner at Preddy Flaherty with Tony Buxton, and I'm here today representing the Industrial Energy Consumer Group. As this committee is aware and others will know, the IECG has represented large consumers of energy in Maine for more than 25 years at all levels on energy policy. We advocate for policies that reduce the cost and climate impact of energy for our members, helping to maintain their operations in our state and the thousands of jobs provided directly and indirectly by those operations. We commend Senator Stewart for the bills before you today, which suggests it would be useful to review the history of restructuring and the regulatory paradigm we have in place now and how it's developed over the years, especially as you consider current and proposed changes to that structure and paradigm itself. It's been more than 20 years since Maine restructured its electricity structures. That effort required 14 separate pieces of legislation prior to its conclusion in March of 2000 when restructuring took effect. Since that time, according to a neat legislative history that ended in 2018, another 69 pieces of legislation that have impacted Maine's electricity structures have been passed. And as this committee is aware, even more have been enacted in the last several years. So it does, to us, seem timely to review the history and how the upcoming challenges may require further changes. Maine currently is fortunate that it has some of the same actors who were involved with these original changes still available to offer their reflections. Folks like Tom Welch, Rich Silkman, Bob Briggs, Mel Hovey, Peter Bradford, and David Moskowitz, and others are still here in Maine and available and could be very helpful both to the committee and ultimately to the PUC if that review is undertaken. As you are aware, there are significant demands for changes to utility structure in Maine and ISO New England that Maine should think carefully about now and over the next several years. The PUC found several years ago the ISO New England does not benefit Maine adequately. This moment of change across many of Maine's electricity structures and its approach to climate change might be a good opportunity to review that, but we'll only be able to do so correctly if we act deliberately and prospectively. And in closing, Mr. Buxton wants to remind the committee of one of his favorite quotes from Mark Twain, that history may not repeat itself, but it certainly rhymes. And with that, I'm happy to answer any questions, and we're glad to participate going forward on these bills.
Thank you. Are there any questions for Mr. Hudson? And it looks like I'm not seeing whose hand it is, but I know there is a hand. For some reason, I don't see it on your screen. Okay, Representative Grochowski. Please
Thank
proceed.
you. Thank you, Mr. Hudson, for submitting written testimony. And I feel obliged, since Senator Lawrence is not with us, to ask. I see you submitted it under one bill, but not the second bill. If you could resubmit it under the second bill. It came through in 1116, but not 1079.
I thought that I had, but it may have been an operator error as opposed to.
It came through as just a blank. You just notified us that you were going to submit something, but it's not this. So if you don't mind, because I know he really likes the record to be we all like the record to be clean, because in 10 years, when we go back to look at this, we'll be like, what happened? So
Right.
thank you for your
That was
diligence on that.
just to be clear, that was 1079, Representative.
Yes.
Thank you. I will resubmit for 1079. And
I also wanted to ask, what did you mean by they still take nourishment? Does that mean they're still alive and eating food?
I believe that's Mr. Buxton's reference to the fact that they're still upright and available to answer committee questions and participate in public policy matters for the state.
Thank you for clarifying. I was unfamiliar with that turn of phrase.
Also, I have flagged the question that Representative Foster asked of the sponsor. While perhaps the PUC may already know that the answer to that question, I will endeavor to, if they don't answer it today during the hearing, I will try to have it in time for the work session. Thank you.
Very good. Seeing no further questions, thank you, Mr. Hudson. And I believe that concludes our testimony in support. So we will proceed to testimony in opposition. And we will hear from Mr. Stephen Weems. Mr. Weems, if you could turn on your video and audio. Looks like you got that. Welcome.
Good afternoon, everybody. Senator Stewart, Representative Berry, other members of the committee. My name is Steve Weems. I'm the Executive Director of the Solar Energy Association of Maine. With respect to the sponsor and the co-sponsors, we'd like to go on record as opposed to LD 1079 for a few basic reasons. One, and most particularly, I'll be brief and follow up with written testimony with apologies for not having it in yet. Sorry about that. To state the obvious, the PUC is extraordinarily busy now. It's a critically important organization on almost every bill that this committee hears, and it's being asked to undertake an enormous number of critical tasks that you're dealing with all the time. What may not be so obvious is that we don't think that this is one of them. It's basically a settled issue. It is good business to re-examine old decisions at a certain point in time, but we hold that this is not the time since deregulation seems to be working fine. And it is a settled issue, as I mentioned. So we're opposed for that general reason, not to overburden the PUC. While it is important to have an open mind on restructuring, we're not interested in going back to the old days. We are interested in the possibility of other structural change that you'll be taking up later in the session, and we'll leave it at that for now. And thank you for the opportunity to weigh in on this particular bill.
Thank you, Mr. Weems. Any questions from the committee? I guess I have one that I'll subject you to, Mr. Weems, and I'll ask if others want to try to answer it in their testimony as well today. Are there any states, and this is not a gotcha question, I don't know the answer myself. Are there states that have restructured and then unrestructured that we know of?
I'll have to defer to other people who know the answer to that because I don't. Thanks for the question, but I'm sorry I can't answer it.
Okay, that makes two of us. Thank you. Any other questions for Mr. Weems? Okay, then I think that concludes testimony in opposition, and we will now proceed to neither for nor against, beginning with Mr. Hobbins, the public advocate. Welcome. And I believe you're muted, Barry. If you could, I'll start the clock over. Once you're ready, take your time.
For some reason, thank you very much.
No problem.
Representative Barry, Mr. Chairman, and members of the Energy Utilities and Technology Committee. My name is Barry Hobbins, and I'm here to testify on behalf of the Office of the Public Advocate, neither for nor against LD 1079, and for that matter, LD 1116, which will follow. The impacts of deregulation are many and far-ranging. Markets have evolved in response to deregulation, so the economic impacts are significant. This bill, in my judgment, is broad in general, making a comprehensive study a large undertaking. If the study is to yield useful information, a snapshot in time would help to focus the discussion. For example, the report could focus on a specific state goal, studying how deregulation has affected Maine's ability to reach that goal and what changes can be made to improve Maine's efforts to reach its goals. With all the interest in the topic and variety of stakeholders that would participate, without a more narrowed focus, it is possible the commission would be swamped with stakeholder input that would be difficult to organize and react. Instead, the likelihood of creating productive input would be improved if specific topics of study were chosen. Also, the committee deems, if they deemed it appropriate, other topics could be excluded. For example, where the commission already has opened up a docket 2020-00344, commission initiated inquiry into performance metrics and regulatory mechanisms for transmission and distribution utilities, and the 2021-00033, an inquiry into small generator interconnection. These topics could be carved out. The Office of Public Advocate has also distributed 2 studies, which I urge you to take a look at and consider. One of them is electricity industry deregulation, a look at the experiences of 3 states by public sector consultants from 2013, and the New Hampshire Public Utilities Commission's report, quote, report on investigation into potential approaches to mitigate wholesale electricity prices from 2015. The OPA would be happy to discuss these reports with the committee at their work session. Again, I commend the sponsors for bringing it forward, in that I think every so often, it's been about 20 years, that you would like to look at to see whether or not this process is working, or whether or not there could be, or whether it should be eliminated, or there could be some type of hybrid process or other changes. Thank you very much for your listening and your attention, and I look forward to working with you in the committee on this bill, and we'll be present at the work session to assist the committee.
Thank you. Thank you. Are there questions from the committee? And seeing none, we'll proceed to Mr. Dan Collins. Welcome.
Well, thank you, Chair Berry and members of the committee and staff. My name is Dan Collins. I am the Director of Government Affairs for the New England Power Generators Association, located in Boston, Massachusetts. NEPCA thanks the committee for this opportunity to weigh in on both LD 1079 and LD 1116. NEPCA is a trade organization that represents electric power generators that compete in New England's wholesale electricity markets. Our members account for roughly 90% of the installed generating capacity in New England and own and operate a variety of resource types. NEPCA neither supports nor opposes, as has been noted, either of the resolves before you, but instead wishes to offer some information that may be helpful to the committee as it considers the objectives of both. First, it's important to recall the objectives of electricity industry restructuring. Before Maine enacted its restructuring law more than 20 years ago, utilities that own generation were not subject to competition and therefore had little incentive to pursue cost-effective investments in the most efficient power plants. Utilities could recover their investments from ratepayers, leaving consumers exposed to the risk of cost overruns and stranded costs. Since restructuring, competition between merchant generators has spurred private investment, lower costs, and greater efficiencies. For example, wholesale energy prices have declined by 51% since 2004. In fact, the average annual wholesale electricity price in 2019 was the second lowest ever since full implementation of the markets in 2003. The markets have also ensured reliability at least cost, most recently through 950 megawatts of additional generation and nearly 600 megawatts of new energy storage resources that includes a major battery storage unit planned for location in Maine, all through private investment. Market competition, among other factors, has also helped reduce carbon emissions from New England's power plants by 51% since 1990. And despite these achievements, NEPCA agrees that wholesale market reforms may be needed to better meet Maine's energy and climate mandates and goals. Those changes could leverage the cost and reliability benefits of the markets, but account for the cost of carbon, the missing element from today's market. A future wholesale market design should also value those dispatchable resources that can maintain reliability, particularly as more weather-dependent renewables enter the system. That's why NEPCA has been engaged with New England states, including Maine, and other stakeholders in some ongoing regional efforts to identify changes to better align Maine's legal mandates and goals with the competitive market, with the competitive wholesale markets. We asked the committee to allow those those regional stakeholder efforts to continue. But in the meantime, I'd be happy to take any questions you might have on these resolves. Thank you.
Thank you, Mr. Collins. And are there questions from the committee? Representative Foster.
Thank you, Mr. Chair, and thank you, Mr. Collins, for your testimony here today. I'm wondering, how far back does your association go? When would that have started?
Sure, it's at least 10 years. I'm sorry, I haven't been with the organization the entire time, but I know it goes back at least 10 years, more than that, really. I want to say it's probably been about 15 years.
Thank you.
Sure.
Seeing no further questions, thank you very much, Mr. Collins.
Sure. One more note, please. I would also note that we do have written testimony that we've submitted on both resolves. Thank you.
Great. Thank you for making sure that gets submitted for the record. Very good. And our next testimony, neither for nor against, will be from the Public Utilities Commission. Mr. Corbin, welcome.
Hi, thanks again, Chair Barry and members of the EUT committee. Good afternoon. My name is Garrett Corbin. I'm testifying neither for nor against LD 1079 on behalf of the Public Utilities Commission. Before I get into my testimony, I don't have any Mark Twain quotes, but I can take on the challenge issued to me by Mr. Hudson. Just asking, the question had come up earlier as to which states have deregulated. And I believe the answer is, here's what I have right now, and I'll double check that this is accurate for the work session. Connecticut, Delaware, Maine, Massachusetts, New Hampshire, Texas, Illinois, Maryland, New Jersey, New York, Ohio, Pennsylvania, and Rhode Island. I believe those are the states that have deregulated electric. So back to my testimony, the resolve requires the commission to establish a commission for the purpose of reviewing the effects of electric deregulation, restructuring policies, and then the commission would be required to report its findings back to your committee by December 1st of this year. The restructuring of Maine's electric industry, which occurred in 2000 pursuant to the law that's now codified in Title 35A, Chapter 32, resulted in two fundamental structural changes to the electric utility industry in Maine. The first is deregulation of the provision of electric supply at the retail level, allowing customers to choose their supply from a competitive market. And the second being a requirement for Maine's electric utilities to divest their generation assets, in other words, power plants and contracts, providing T&D service only. Those structural changes in turn were rooted in two views. One, that electricity supply should not be a monopoly service. And two, that the risks associated with investment in and contracts for generation should be borne by entities other than the utility customers. Individual customers may now choose a retail service provider, or if they do not do so, they receive standard offer service, which is procured by the commission on an annual basis through a competitive solicitation. With respect to retail supply, the commission can provide a report on the relative prices paid over recent years by residential customers who selected a retail supplier as compared to those who received the standard offer service. The commission did, in a 2018 report, provide the relative prices paid by residential customers that chose a competitive supply compared to the standard offer prices, and additional information is provided in a table attached to the testimony as well. The commission notes that at the time the 2018 report was submitted, residential customers had paid significantly more for competitive supply than they would have paid under the standard offer, whereas commercial and industrial customers are likely to have benefited from the ability to custom tailor their purchases from a competitive supply market to their needs. Regarding the review that is described in this act, the language is very broad in LD 1079. So we are unclear which aspects, particularly of deregulation, would be intended to be the focus of the report. So greater clarity on the issues to be explored would help ensure the report addresses the questions or concerns giving rise to the resolve. And finally, the commission questions the usefulness and efficiency of the requirement to establish a separate commission to conduct the review. Reviews led by the PUC ordinarily seek input from all interested stakeholders and fully document and consider that input. If the legislature wishes to proceed with this through a separate entity other than the commission, it may be more appropriate for the committee to craft the organizational details, membership, and directives for that entity.
Mr. Corbin, I apologize for interrupting, but you have exceeded your 3 minutes.
I was right there. Thanks so much. Welcome any questions.
Great. Thank you very much. I think the answering that question at the beginning added a little bit to the time. So any questions from the committee for the Public Utilities Commission? And it looks like Representative Foster is up first.
Thank you, Mr. Chair, and thank you, Mr. Corbin, for your testimony. I'm wondering if you might, for the work session, if the PUC might be able to supply us with, recognizing that this bill we're talking about here, it does have kind of a broad scope, if you will, of what we would be looking for. I'm wondering if the PUC might be able to provide us with a list of items that the PUC might think valuable to look back at in this regard. In other words, issues that the PUC deals with or has dealt with that might prove of some value to consider both what the intent was and where we're at today. And it doesn't have to be a complete detailed list, but I'm just generalities in regards to this subject. Thank you.
Right. Sure. Thanks, Representative Foster. Happy to get back to you with that.
Okay, seeing no other questions. I believe that concludes our testimony on this bill, and we'll hear a similar bill and a similar cast of characters, I believe, soon. But first, Jordan, and that's it, right, for testimony?
Yep, that's it for 1079.
Okay, thank you. All right, well, we will now conclude, in that case, the hearing on LD 1079. And that will bring us to LD 1116, which is also presented by Senator Stewart. So welcome back.
Hello again, Mr. Chair. And my fellow colleagues on the committee, as you know, I'm still Trey Stewart and I still represent Senate District 2. This time I'm before you to present testimony on LD 1116, resolved to require review of the outcomes of utility restructuring and electricity generation divestiture. It's a mouthful. The resolve before you is emergency legislation directing the committee to hold 3 public hearings this session on lessons learned from the restructuring of Maine's electric industry that took place in 2000, as well as the required divestiture of utility-owned generation and the creation of ISO New England. I believe these public hearings will be beneficial as they'll provide this committee a look into the history, goals, and successes of the restructuring which took place 2 decades ago. This resolve also requires the PUC to hire an independent consultant to review and report on current proposals that will help us to better align the clean emergency and decarbonization objectives, particularly as they relate to reliability, efficiency, and resource neutrality in the New England wholesale electricity market. The commission will report back to the committee by January 15th, 2022. And should the committee feel the need to report out a bill based on the consultant's finding, we could do so at the time. We've all seen the impact that energy policy that's not well planned and thought out can have on consumers, and need look no further than the recent energy crisis in Texas. We should want to avoid scenarios like that in Maine, and helping to develop a proposal that will be the safe and effective with regard to accomplishing our clean energy goals in Maine over the next 30 years will go far in allowing us to avoid a Texas level event while accomplishing our decarbonization goals. From time to time, it's important to reflect on where we were, where we are, and where we want to go. This bill will assist the committee in that effort and provide us more information on where we've been and what our goals were when we made the most substantive change in energy policy in my lifetime. From there, it will also help us chart a course that will help protect the next generation of Maine energy consumers while also decarbonizing our electric grid. And again, I'd like to make a couple of points too, if I can divert from my written testimony briefly, that both of these measures in no way are implying that we should, relitigate history, that we should turn back the clock to pre-reorganization of our energy sector. It's simply saying that we need to figure out what exactly the point was, how far we've come in those objectives in the last 20 years, and if those objectives remain consistent with what we seek to accomplish over the next 20 years. And so I do think that this is an important question that all stakeholders that we're going to hear from on this bill and heard from on the other bill should be concerned with and want to know about. And I do take slight issue with the notion that we may not, that the certain interest group may say that we shouldn't devote any time to trying to figure this out. I don't think that makes any sense at all, and isn't within their purview to make those calls. It's within this committee's purview to make those calls. And I think that it's really important that we maintain that independence going forward, because there's a ton of pressure, particularly in this committee, from stakeholders on both sides of every issue. And it's important that we consider what's important to us as the elected folks in the room to chart a course that makes sense for our state going forward, that is consistent with the needs of our constituency and the state of Maine, and not one interest group over another or one ratepayer over another. And so with that, I do hope that we can come up with some sort of review process that makes sense. And again, I'm not wedded to any one of these ideas. In fact, that's why there's two different bills that do different things, right? But the point is that we review where we've been over the last 20 years to make sure that we are consistent in what we hope to accomplish going forward. And with that, I'm happy to answer any questions that my colleagues have. Thank you, Mr. Chair.
Thank you, Senator. Questions for the sponsor? I guess I have one, Senator. I wasn't making policy in 2000, and neither were most of us on this committee, with the exception of Senator Lawrence. But I do have looked at that period as well, and I find it fascinating that the state, like a number of other states that had very high costs at the time, did take that leap to require the utilities to sell roughly half of what they were worth. And not only that, but that the utilities, once they were assured that any investments that they had made that where they expected future profits to come from, that they would be compensated, so ratepayers would pick up that tab as well, that they did support that that decision. Is it your general feeling that was that move towards a free market and that agreement with the utilities to require them to sell half of their assets was a bad move?
I wouldn't say it was necessarily a bad move. I think it was a significant move, right? And one that has a significant amount of policy considerations going forward, which we deal with literally on a daily basis in this committee. And we deal with those policy considerations, I think, with few exceptions, and Senator Lawrence being the one, right, who could actually tell you this is what we intended to do 20 years ago, or more than that at this point. And this is how it's actually played out, right? And that, I think, is the missing piece in all of this, that we're hamstrung in so much of what we do based on what was decided over 20 years ago. And that's fine. I just want to make sure, and again, I'm not trying to relitigate the issue or say that we should go back to, a sort of, vertical infrastructure with regard to our utilities. I'm simply suggesting that I'm sure that group of folks had a number of goals in mind. Did we accomplish them? Did we fail to accomplish them? Why? Why not? And are those goals consistent with the goals that this policy committee has today? And if they're not, how can we, if they are, then great. What can we do to further advance them? But if they're not, what tweaks can we make going forward that will provide even more of a benefit to ratepayers who, as you heard previously in testimony, they received a benefit in large part because of deregulation on the T&D side. Maybe that's the case on the generation side as well. Maybe it's not. But the point is, it is hard to compare as well, right? Because we essentially have to compare, a history of something that never happened, right, in the state of Maine. And so it's a challenging question, but it's an important one, and one that has implications for so much of the work that we do in this room, that I think it's been long enough now, almost the length of my life, that we can hit the pause button for a second, review what it was they were trying to accomplish back then, figure out where we're at in that process, and then, incorporate that into our course going forward. And I think that some of the resistance to this is more on the lines that, we're not trying to backdoor anything here, right? It's literally just a review. So I am a little frustrated that that's some of the speculation from some of the folks that are concerned about, their vested interests over just a general better understanding of what it is we are trying to do, where we're at, and where we're going.
Thank you, Senator. And I do have one other question for you, which I'll try to make it quick on my end, which is, there's been talk about what the PUC, can take on, and it also strikes me that you're asking for, our committee to really dig in. So I'm wondering, is this something that you could envision the committee doing in some off-session meetings?
So again, I'm not wedded to any one idea. I think that the commission has a significant amount of expertise in this, right? And that's why I think that's sort of a place of natural fit for a request like this. That said, if the committee, we're doing a similar effort right now with like the NEB subcommittee that we've sort of started and are working towards at a fairly good pace right now, I think. I could envision doing something similar to that, right? I mean, just because the first, bite of the apple in the first draft of the bill says, well, there'll be 3 public hearings on that. Well, maybe we figure out 2 is fine, or maybe we just relegate it to a subcommittee and, work it that way. But the point is, we're working towards getting a product that will actually have some useful information in it that we can use to make sure that what we do going forward is consistent with, or isn't, right? Or isn't consistent with it. And that's okay too. But the point is, we'll know where we've, what it is that we've been trying to do. Long-term in the legislative life is 2 years, right? And that's not really long-term at all. I view long-term as 20 years, which is right where we are in this process. And I think it's time for a review. but that's how that review takes shape. Doesn't make a big difference to me.
Great, thank you for exploring that a little bit for me. Okay, any other questions for the sponsor? Seeing none, we will proceed to testimony from Mr. Hudson in favor.
Thank you very much, Mr. Chair. Representative Barry, members of the committee, I'm still Stephen Hudson. I'm still not Tony Buxton, but I am still a partner of Purdy Flaherty and here on behalf of the Industrial Energy Consumer Group. I'm not going to repeat my testimony. I would like to endorse the remarks made by the sponsor of the bill just now, which I think laid out our understanding of his intention, that it's hard to move ahead in a thoughtful manner until you understand how you got to where you are. And I think doing this so in the light of all the challenges, whether it's climate related or other issues before us, is important. The only part that I have to take issue with is his reminder of how old I am, since the 20 years has not been most of my life. But other than that, I'll be glad to answer any questions. And I think that a lot of the comments I've heard today about these bills are people not necessarily taking a lot of issue with the idea of doing it, but it's a question of how broad is it, and do you need to be a little targeted? I think that there's some very good topics that are worth examining. We've seen a lot going on with distributed generation, grid scale generation, who owns wires, who owns the generation, and what kind of consumer choice should we provide? What type of options should be provided for consumers to purchase the electricity supply they prefer? I think all those topics are at least worth examining in this overall context. I'd be glad to answer any questions, and obviously we'll be here at the work session.
Thank you, Mr. Hudson. A question from Representative Grahowski.
Thank you, Mr. Chair. Thank you, Mr. Hudson. I'm curious, I mean, I think it's really interesting. I love to gather information and data and think about how we are, where we are, and what we like about it and don't. But could you think of like a concrete example of what we might learn that would affect our policy moving forward? Because deregulation is something that it seems like we're either doing it or we're not doing it. I don't know how you, I'm curious if you could think of an example of something that would inform our work going forward that would come out of this sort of study.
Well, I think one of the things that I'm aware of that this committee just dealt with issues last week regarding, or the week before, regarding the issues of customer choice, retail electricity supply, and I think that's something that could be looked at. Clearly, the committee has spent a lot of time looking at the issue of who owns main transmission and distribution wires. I think you could spend some time looking at that in that overall context. I think we're also, the committee has spent a lot of time thinking about how to help Maine accomplish its climate goals. And I think understanding where we've gone and where we could go will help us make better decisions. I think what has struck me in the last week or so is that I've heard members of the Republican side and members of the Democratic side say, what's the plan? We need a plan. And I think this may be a way to help us begin to understand what elements of the plan ought to be in place.
Representative Grahowski, did that answer your question? Okay. In that case, Representative Wadsworth.
Thank you, Mr. Chair. Mr. Hudson, a couple of years ago, I got to tour Hiram Falls, which is a dam on the Saco River that was built in 1917, and Brookfield owns it now, and CMP was forced to sell that in 2000. They told me that the water lubricated turbine in there has been spinning since 1917. They haven't had to do anything with it. So would the ratepayer have gotten that benefit now that the Brookfield shareholders are getting it? So I guess I'm a little confused. I don't know if you could speak to that. Just seems like now the shareholders get that benefit when the ratepayer would have got that benefit before we were forced to deregulate.
Right. It's a question of, I think, and I was not here during that deregulation phase, although my partner was, and Tony Buxton, he'll be glad answer some of those questions. But I think it's important to understand that ratepayers were compensated. They took their that compensation came in the form of some of the gain on the assets that the ratepayers had paid for. And so that gain was realized years ago. And the question of whether you take your gain now or you take your gain at some extended point over time is an important balance. And sometimes it depends on what the interests of the person who's receiving the money is, in terms of, do the ratepayers want those reduced rates now, or do they want to have some certainty of rates going forward? And that's something that I think the committee needs to think about.
Thank you.
Seeing no other questions, we will proceed to testimony in opposition. And first up is Mr. Stephen Weems.
Thank you again, Senator Stewart, Representative Berry. My name is still Steve Weems, Executive Director of the Solar Energy Association of Maine. I'll just take a minute. I'll make a comment. I almost decided to, in deference to Senator Stewart, I am definitely listening, sir, and stand chastised if it sounded like I was pontificating about as if I were an elected official. I didn't mean to do that in any respect, and have the utmost respect for all of you folks who are providing this public service. But I'm not going to go into the neither for nor against. I'm going to stay in the opposed category on LD 116 or 1116 for essentially the same reasons. It's basically how much work can your committee, how much work can the PUC, how much work can all of us do in a day? And is this a critical issue of this day in this session to get addressed as envisioned in both of these bills? So I'll just leave it at that, because that's my main hesitation here. It put me down as a skeptic, not so much in opposition. Based on that reason, I'm always in favor of being intentional and re-examining where we've been and where we're going to go. The only other thing I'd point out is that clearly one of the prime objectives, if not the prime objectives back 20 years ago, was to get more competitiveness in the energy markets. And as Mr. Collins said a few minutes ago, that objective has been served mightily well. Our problem isn't that energy costs are driving our electric bills. It's the transmission and distribution costs that are driving our electric bills, and the basic reasons of deregulation appear to have been achieved extremely well. I'll leave it at that, and appreciate the opportunity to come back in and say a few words.
Thank you, Mr. Weems. Any questions? All right, seeing none, appreciate your testimony, and we'll go to the public advocate.
Good afternoon or good morning. Good afternoon, members of the committees, Representative Berry. I'm Barry Hobbins. I'm the public advocate, and I am here to speak neither for nor against this bill. I did not provide any written testimony, but I do want to just bring up a couple points. One of them is that this bill adds specificity to the study bill that we discussed before, and this one would focus on the greenhouse, what is known as GHG, greenhouse gas reductions, which makes this study a targeted study, as I referred to in my presentation on LD 1079. The OPA does not represent customers on climate change initiatives unless and until they show up in rates, and I basically feel that I can add some input, but I would suggest that adding an element that looks at the impact of greenhouse gases and related policies should look and see how they are affected on low-income utility consumers. And I wish that that would be a consideration. However, this could be done by PUC study at this PUC study level if the bill was to pass. So those are brief remarks just to give you some input of this particular LD as it relates in somehow to the approach of 1079. If you have any questions, I'd be more than happy to answer them.
Thank you, Mr. Hobbins. Any questions from the committee? All right, seeing none, we appreciate your testimony as always.
Thank you.
And up
Me
next,
too.
Dan Collins.
Thank you, Chair Berry, and members of the committee again. And I don't want to use up too much more time. We did basically hit on all the issues in my previous testimony on 1079. Those really apply as well to 1116, and our written testimony does the same. I would just like to quickly, while I can, respond to Representative Foster. He had asked me earlier when NEPCO was started. That date is 2005. So if that helps. And also too, I wanted to just reassure Senator Stewart that we are not opposed, as you know, to these proposals. We recognize that's certainly the prerogative of the legislature to take any action that it deems necessary. So to the extent that there was any confusion about our comments about that matter, we're not opposed. We just simply point out that there are other initiatives going on around the region to address what is essentially a regional issue, given that it is a regional grid that we're talking about. But again, Maine will certainly need to examine for itself what is right for Maine consumers. And I'll just leave my comments there. Thank you.
Thank you, Mr. Collins. Seeing no questions from the committee, we appreciate your testimony. And we'll go on to the Public Utilities Commission and hear from Mr. Corbin.
Good afternoon again, Chair Berry and honorable members of the EUT committee. I'm still Garrett Corbin, testifying neither for nor against LD 1116 on behalf of the PUC. The first section has been referenced, provides a review by your committee, as described by the sponsor. And the second section requires the commission to hire a consultant to review and report on proposals that better align decarbonization objectives adopted throughout New England with the three priorities of reliability, efficiency, and resource neutrality, and how such proposals benefit Maine consumers through electricity generation delivery improvement. As I described while testifying on the last bill, the restructuring of Maine's electric industry in 2000 contained two components: the deregulation of retail supply and the requirement for utilities to divest their generation assets. At around the same time of Maine's industry restructuring, the Federal Energy Regulatory Commission, FERC, began approvals of state or regional system operator plans to oversee the development of wholesale electric markets, ensure adequate transmission build, and to adopt rules and policies to maintain system reliability. That federal action led to the creation of the Independent System Operator New England, known as ISO-NE New England, for the 6 states in this region. The review required by the resolve involves the ISO New England's functions and its alignment with the clean energy and decarbonization objectives adopted by New England states. The Commission notes that there are already significant efforts underway in the region to address the concerns in the resolve. These include one study called the Pathways to the Future Grid. That's a joint effort between ISO New England, the NEPOOL Participants Committee, and the states to conduct an analysis of how wholesale market rules could better accommodate the energy policies of the New England states. And then there's a future grid reliability study underway at the moment as well. That's also a joint effort between ISO New England, NEPOOL, market and reliability committees, and the states to examine the operating characteristics of the future grid. That study objective is to assess and discuss the future state of the regional power system in light of current energy and environmental objectives. And then there's a third study that's about to commence called Transmission Planning for the Future Grid that its name states its objective. The first two of these studies are anticipated to be concluded by early 2022. Then that third study that's looking at what's needed for resources by 2050, that one, the completion is not yet known, but it would be further out. But the commission's engaged in these regional discussions about all of these issues and these studies, and providing input either individually or collectively with other states as appropriate. Finally, the resolve requires the commission to hire an independent consultant to conduct the study. The commission notes that the study is likely to be costly and not within the commission's existing budget. It should also be noted that in our view, it's unlikely that any single consultant would have the capacity to reliably produce these studies on their own. As I just noted, there are several regional entities and states involved in those studies at the moment. So as an alternative, the commission could provide a report or similar communication to the committee with more detail on the ongoing efforts in place to address the concerns in the resolve, and we welcome any questions.
Great, thank you, Mr. Corbin. Any questions from the committee? All right, seeing none, we will proceed to hear from someone we haven't heard from on these issues, and that is the Governor's Energy Office. Ms. Winnie, welcome.
Great, thank you, Representative Berry and members of the Joint Standing Committee on Energy, Utilities, and Technology. My name is Melissa Winnie, and I am the Energy Policy Analyst with the Governor's Energy Office. The Energy Office testifies neither for nor against LD 1116. Primarily, I wanted to speak today to the component of the legislation related to the PUC study. As is referenced in the resolve, there's a number of ongoing planning efforts and studies related to the regional electric grid and future grid management and market changes, a few of which were just noted by the PUC. There is kind of another grouping of efforts, and I wanted to provide just some reference and information on what those are. In my written testimony, there are links to the reports and websites related to some of the high-level notes I'll make now, and I'd be happy to kind of elaborate further during the work session if there's any specific questions. In October 2020, governors from 5 Northeast states, including Maine, issued a statement calling for reforms of New England's regional wholesale electricity market needed to achieve their state's respective goals for clean, affordable, and reliable electricity. Again, I linked to that letter in my testimony. Following that, there's a joint statement from the New England States Committee on Electricity, also known as NESCO, and that's a nonprofit entity that represents the New England states in regional electricity matters. And that vision document outlines more specific areas of reform, and that's in 3 kind of core segments: wholesale electricity market design, transmission system planning, and then ISO New England governance. From that vision statement, NESCO and the New England states held a number of technical forums earlier this year, again on those topics, so wholesale markets, transmission planning, governance reform, and then equity and environmental justice. And following each of those technical forums, there was an opportunity to provide written comments from the public. And then I also did note the future grid reliability study and the pathways to the future grid study that the PUC just outlined as well. So all of that to say, you know, we recognize the complexity of these topics and processes and the importance of ensuring that the EUT committee understands the current status and objectives. And in regards to the other portion of the legislation, we're open to the committee's interest in hearing from the public and stakeholders, specifically regarding restructuring and deregulation. We do want to ensure that the specific study request is not potentially duplicative of some of these existing initiatives and public sessions that are being held at the regional level, and also that they're not preemptive of findings from some of those, either the public hearings or some of these studies that may be helpful in understanding these issues a bit more. And similarly to the PUC, the Energy Office is staying closely engaged in a lot of these regional conversations and planning processes, specifically the NESCO efforts. And so happy to provide more information on those. And with that, thank you, and happy to take any questions here.
Thank you, Ms. Winnie. Any questions from the committee? All right, seeing none, we appreciate your testimony. And I believe, Jordan, that brings us to the end of those wishing to speak on this bill. Is that correct?
That is correct.
Great. Okay, so I think the committee has earned an hour for lunch. If there are no objections, I think what I'd like to do is adjourn us until 1:45. We do have 3 bills to go. So we'll want to come back. I'm hoping we will have a senator and a quorum at that time. That's always preferable. So I'll double check, but otherwise, let's plan on 1:45, and we'll take up those bills in the order advertised in the weekly schedule that goes out on Friday. For those listening, keep in mind it's never the order, or almost never the order posted on the legislature's website, but rather what is sent out by our committee clerk on Fridays as a weekly schedule. So very good. With that, let's turn off video and audio, and we'll be back at 1:45. Senator Lawrence, you are muted. I don't know if you're speaking to us or someone else. Welcome back, everyone. Glad to have Senator Lawrence back with us so that he can chair the afternoon's proceedings. And Senator Lawrence, I think we have a quorum, so whenever you want to unmute yourself, we can.
Okay, I'm talking with our analysts right now, so
Oh, I'm sorry.
just
Okay.
going to be offline for a couple of minutes while I figure out what we're doing. Well, good afternoon, everyone. I hear you had a long morning doing a few bills. Our analyst Deirdre Snyder can't be with us this afternoon. She has something she has to attend to, so I believe Dan Tartikoff, our other analyst, is going to be subbing in. Are you there, Dan?
I am, yep.
Good. I just wanted to make sure you were there. We have 8 members, 1, 2, 3, 4, 5, 6, 7, 8. So we have a quorum. And let me get back to my witness list or testimony list. And obviously now is the time my computer chooses to act up. So we are on LD 1332, I believe, an act regarding net energy billing limits. And is this Senator Stewart's bill or is this your bill, Representative Berry? Okay, good. So we'll start off. Oh, I see your name right there. Okay, we'll start off with testimony on this by hearing from the sponsor, Representative Berry.
Great. Thank you very much, Senator Lawrence and members of the committee. Good to be with you to present LD 1332, an act regarding net energy billing limits. And I am Seth Berry, representing House District 55. LD 1332 would effectively close a loophole that our net energy billing policies have had really since the beginning due to system capacity issues in the former Maine Public Service territory. And if any of you needs a map that shows that territory, I'm sure that Representative Grahowski can help with that. The Maine Public Service territory used to be its own utility. It was then, it came under the ownership and operations of Bangor Hydro. Since then, of course, Bangor Hydro has been purchased by Emera Maine, and now Emera Maine is Versant, which interestingly is owned by the city of Calgary in Canada. And Versant manages both the former Bangor Hydro territory and the Maine Public Service territory. The particular idea here comes from a prohibition on shared financial interest net energy billing for in the case of this northern Maine Public Service territory only, no more than 10 eligible customers or meters. So you can share with no more than 10 others. And as you know, in the rest of the state, we have lifted that cap entirely. So there's no limit on the number of eligible customers or meters who can share in DG resource. Again, this had to do with system capacity, and it's the billing system really that needs to be able to handle it. The feeling was it's onerous when it needs to be done by hand with an old-fashioned system, and that's what they were working with in the MPS area. So fast forward to today, and we do understand from Versant that as promised before by Emera Maine and now by Versant, that the new billing system that's coming online, which I believe is part of the reason the utility is asking for a 25.4% rate increase, that will be able to handle this unlimited capacity that we apply in the rest of the state. So I wanted to make sure that this idea was put forward and that we close this loophole for the MPS territory. I am hopeful that we will hear from Versant, although I'm a little concerned I didn't see them on the list of attendees. Perhaps they'll jump in or appear at the work session. But I had heard from their representative, Mr. Feigenbaum, that they were very, very close, on the verge of having this billing system at the ready. And certainly by the effective date, it sounded to me of this bill, if we pass it as a non-emergency, they should have no problem implementing the same policy that we apply in other parts of the state for investor-owned utilities and larger utilities. So with that, I'm happy to try to answer any questions.
Are there questions from the committee for Representative Berry? Yes, Representative Foster.
Thank you, Mr. Chair, and thank you, Representative Berry, for bringing this bill forward. I'm just curious, you mentioned during your testimony that you think the rate increase request may be tied to the fact that they had to install this new software, billing software. Can you confirm that, or is that just speculation?
It is actually, I haven't looked into the precise details. I think there's also some metering work that's been done, some additional hardening of the grid that they're proposing. So it's a number of things. It's certainly not just this billing system work that leads to the 25.4% rate increase. And as you know, Representative Foster, whenever a utility does invest in infrastructure, such as these things we just named, and those investments are approved as prudent, the rate hike, it needs to happen, because the utilities do have a constitutional right to not only recoup the investment, but also a return on that investment. So I think all of those things contribute to that 25.4% increase.
Thank you.
Any follow-up, Representative Foster?
No, thank you, Mr. Chair.
Okay. Any other questions for the sponsor of this bill? Great. And I do not see that we have any co-sponsors who are going to testify. We do have somebody from Versant here who's going to testify. So I'll ask Jordan to bring James Cody on after Stephen Weems. And we'll go first to Stephen Weems from the Solar Energy Association of Maine. Excuse me, Stephen.
Thank you, Chair Lawrence, Representative Berry, members of the committee. My name is Steve Weems, Executive Director of the Solar Energy Association of Maine. We're pleased to support LD 1332. Hopefully Versant will agree with us. Northern Maine residents, businesses, schools, municipalities, and others should be able to participate fully in the clean energy economy. And the whole state needs this too to meet our decarbonization goals. For example, think how important Aroostook County has been in the wind energy resources area. So we're on board. We hope that this is all going to work and that Versant will support it, and we'll support written testimony to this effect today. And thank you for your time and opportunity to support this bill.
Thank you very much, Steve. Other questions for Steve from the committee? Seeing none, thank you. And I believe next we have James Cody speaking on behalf of Versant in favor of this bill. James?
Yes, Senator Lawrence, Representative Barry, and members of the committee. James Cody on behalf of Versant Power. I would say that we filed our testimony neither for nor against, but I think it gets to the same conclusion, which is Versant Power has been working last year to adopt this system expectation within our Northern Maine service territory. And that change is on track to be operational by September of this year, which we believe would be consistent with the time frame outlined in the legislation. So whether or not legislation is deemed necessary, obviously we defer to you, but as long as everyone's under the same understanding that September would be the operational date, we are on track to meet that target.
Great. Other questions from the committee for James? Representative Grochowski.
Thank you. And I want to say, Mr. Cody, thank you so much for your company's diligence in moving this forward. I know I had a lot of conversations last year on this front in which I was told that the billing system was something like an old 1980s Commodore machine operation, which I had to look up because I wasn't even alive then, I don't think. But so I want to thank you for moving this forward. I think I just want to get your view on this because the statute is pretty clear right now and lengthy about this exception. I think if we're moving forward to a place where your company is comfortable doing this and has the resources, would it seem prudent to you that we pass this bill in order to clean up the statute there where it's no longer a necessary exemption?
Excuse me. Yeah, as a housekeeping matter, I think we would be fine with that. And further, we'd be more than happy to maintain a dialogue with the committee through the end of session to just keep you apprised of where we are in the process. But everything looks like it's in really good shape on that front.
Are you all set, Representative Grochowski? Okay, Representative Barry?
Yes, thank you. I just want to say thank you, Mr. Cody, for jumping in because I had not seen your testimony. I think it was filed early this morning and didn't see you on the list. So was hoping to hear from Versant, and I appreciate your chiming in today.
Great, thank you very much, James.
Anytime.
We'll now go on to Garrett Corbin from the PUC, speaking neither for nor against. Garrett?
Good afternoon, Senator Lawrence, Representative Barry, members of the Energy Utilities Technology Committee. Garrett Corbin testifying neither for nor against this legislation on behalf of the PUC. At this point, I'm not sure we have a lot to add. Our written testimony just provides some background as to why the rule is the way it is now and recommends consulting with Versant to see whether they have the technical capacity to carry this out. So having just heard from them, what I'd like to ask of the committee, and looking forward to the amount of testimony we have on the next bill, I'd like to see if I could reserve some credit for the excess time from here on and use it in the next hearing. With that, I welcome any questions. Thanks.
Thank you, and I'll take that under advisement. Questions for Mr. Corbin? Seeing none, thank you. We'll now go on to our public advocate, Barry Hobbins, testifying neither for nor against this bill. Barry?
Good afternoon, Senator Lawrence and Representative Barry and members of the Energy Utilities and Technology Committee. I am still Barry Hobbins. I am still the public advocate with the Office of the Public Advocate. I am here today to testify neither for nor against LD 1332. First of all, the OPA is very supportive of the participation of the net energy billing and appreciate Representative Barry's submission of the bill. We would also like to echo the sentiments of those who have testified before us. However, it would be difficult for this office to support this piece of legislation if it results in an increase in rates in order for the utility to institute this policy. We hope that the utility, Versant, would be able to implement this change under their current customer information modifications, system modifications, I should say, to accommodate the solar, community solar changes that are proposed. As you probably know, there is a pending rate case that is being aggressively examined by our office during the process before the Public Utilities Commission. I do not know whether or not this has been one of the asked or in the mix. If it was, we're going to have a discussion at some point. But we're hoping that, hearing from Mr. Cody, that they're supportive of this. I'm assuming and presuming that they're going to do it within the present budget structure and through their infrastructure, and not bake this into the rates. Thank you.
Thank you. Are there any questions from the committee for Mr. Hobbins? Seeing none, thank you. Jordan, have I reached everyone who wants to testify on this bill?
That's everyone I have listed for 1332, yes.
Great, thank you. I'll declare the hearing closed on 1332. Just to update members and the public that may be listening in, we have 2 more bills left. I believe we're going to be going next to Senator Woodsum's bill. Is that correct, Representative Berry? Or are we doing yours before his?
I think the order on the weekly schedule would have 1025 first. That's mine.
Okay. So we'll do Representative Berry's bill next, and then we'll go on to Senator Woodsum's bill, which is 1100. And I expect testimony to last about a half an hour on each of them. So that should bring us up to just about 3 o'clock when we'll conclude today's hearings. And we'll update on tomorrow's happenings. Representative Berry will now go ahead with LD 10. Let me bring up the testimony list. 1025. An act to allow a customer with a net energy billing arrangement to annually donate to any unused kilowatt hour credits. Representative Berry.
Great, thank you very much, Senator Lawrence, fellow members of the committee. My name is Seth Berry. Today, I'm presenting LD 1025, and you've already heard the title. So with this bill, it was not my intention, I should say, to reach into the larger net energy billing arrays, such as those over 2 megawatts. We may need to tweak it slightly. Instead, I really had in mind to reach the smaller rooftop arrays that many Mainers have put in place. And due to the pandemic, in many cases over the past year, many of these arrays have been producing free energy for which the utilities have not had to pay. This was especially true for arrays sized with an electric vehicle or 2 in mind. With many of us working from home, many EVs have stood still while the sun shined, and a great deal of net energy was produced. And just to back up, as you all know, net energy billing provides a customer with the ability to bank credits for each kilowatt hour they put onto the grid. That typically displaces much larger natural gas-fired generation, which comes at a cost to all of us. And also it displaces the need for more rapid investment from the utilities and poles and wires and so on, especially at the smaller scale when it's sited close to load. Because both of these do reduce profits to these industries, the gas generators and the utilities, net metering has been opposed across the country, and in some locations significantly curtailed. Net energy billing customers, we should also always remember, do pay a monthly fee to be connected to the grid. I think it's around $14 per month in CMP territory. And they are also allowed to bank, and this is important, only what they use in the course of a year. If they produce more than they use, then these kilowatt hours are they're provided free to others. They're a reduction really in what the utility has to procure for other customers. It's not clear to me, and perhaps some others can elucidate today, exactly how these free kilowatt hours are reported by the utilities to the PUC, and then who benefits from those. So I hope to find that out. But the purpose of the bill is simply to allow a customer to donate those credits if they have excess that they will not use. Do it once a year, no more than that. And I think a good parallel is to think of the chickadee checkoff, in which you can send a portion of your income tax return to certain nonprofits, right? That's something we've had around for a long time. It's always a fun thing to work those bills in the tax committee, in my experience. This donation of excess credits could be made once a year, as suggested in the bill. And perhaps it could be to a limited number of nonprofits to keep things simple. It doesn't have to be to just anyone. The PUC could implement the details of it to make sure that it is not administratively burdensome with appropriate rulemaking authority. I don't think those need to be major substantive. And that's basically the concept. Your ability to donate your excess credits to someone, they could use them, and perhaps to a nonprofit that's benefiting others in our state. So thank you for listening, and I'm happy to try to answer any questions.
Are there questions from the committee, Representative Barry? Representative Grochowski?
Thank you, Mr. Chair. Representative Barry, I'm curious, it seems like that ability to not continually roll over your credits, I think, is in part because the goal was to have people right-size their installations for their use. Of course, that could change over the lifespan of solar panels with efficiency and other things. But so I'm wondering if you think there could be any adverse effect if, in terms of designing these installations for the locations they're trying to serve, if people know that there's like a charitable, I think it's good that it's a charitable opportunity, not a financial opportunity. But do you have any concern about consequences of that to the design?
So I think if it were other than charitable, then yes, I would have that concern. I think people would be more inclined to supersize their systems if they could sell the kilowatt hours for 16 cents, and that's not what I'm proposing. I do think that this would be, by and large, a pretty small stream of beneficial activity, but nevertheless it would be beneficial, and it would help to make sure that those excess credits are doing some good in our community. I again don't have clear visibility into how who is benefiting from them right now, and I think this would be a nice way to make sure that customers can choose a charity and make that donation.
Representative Grochowski, did you have a follow-up?
Yeah, I just was wondering, and I'm no expert on charitable write-offs, given the income threshold we reach in the legislature here, but I'm curious if this is something that you think would be something that a person could write off in their taxes, or is there a way to completely disincentivize this for anything other than goodwill purposes?
Yeah, I don't see how exactly you could file that as part of your your charitable giving on your income tax. I suppose I can ask the Maine Revenue Services, if you like, Representative, how they would see this sort of donation and whether they feel that it would be considered a tax write-off. But considering that you just lose the money right now, I don't see how you would necessarily, with a straight face, get to turn around and take it as a tax write-off. So it's certainly not my intent, and I'll look into whether it needs to be clarified with Maine Revenue Services to make sure that we don't accidentally create too much of an incentive.
Other questions? Representative Grochowski, you fine? Great. Other questions from committee members? Seeing none, thank you very much. I think we have a co-sponsor here who's interested in testifying. So I'll recognize Senator Stacey Brenner.
Thank you, Senator Lawrence. I have about a 30-minute testimony, so I might keep you here longer than your 3 o'clock planned departure, but it's nice to see you all. Senator Lawrence, Representative Berry, and honorable colleagues of the Energy, Utilities, and Technology Committee. I'm Senator Stacey Brenner, and I represent Senate District 30, which includes Gorham, most of Scarborough, and part of Buxton. I'm here today to speak in support of LD 1025. Like many of you, I have a handful of constituents who really stand out. I first met David Johnson in the summer of 2020, and we hit it off right away. Then he reached out to both Representative Berry and myself in January, and his email read, I quote, "I have solar panels and generate more than I consume. In fact, I had credits expire totaling 1,664 kilowatt hours so far. It's always rankled me that these essentially become a gift to CMP. So today I called CMP and made a request, which they promised to run up the flagpole there. If my credits expire and CMP didn't earn them, why can't I choose to have them donated to people having trouble meeting their electric bill?" Unquote. He was told this wasn't possible without approval from the PUC or the legislature. Representative Berry replied immediately that he'd introduced a bill just about this issue, and I agreed to co-sponsor it, and that's what brings me in front of you all today. I want to support Generous Mater's attempt to creatively offer charity in small and meaningful ways. I'm admittedly unschooled in the intricacies of the EUT policy work, but as a rooftop solar owner, I can sympathize with Mr. Johnson. We've added more efficient practices to our farm business over the years, and our rooftop solar system is occasionally producing more than we consume. I've read the submitted testimony from both the PUC and the Office of the Public Advocate, and I still have one big question about why Mr. Johnson was unsuccessful trying to donate his credits. The PUC states in their testimony that there's a vehicle for the allocation of kilowatt hour credits among shared financial accounts over a 12-month rolling period. Credits still expire at the end of the year, and the residual value is thus unrealized to anyone but CMP. The sharing arrangement apparently needs to be identified in advance, and credits can only be donated monthly, not once at the end of the year. So my question is this: why did CMP fail to alert my constituent to this already existing program? The recommendations put forward by the Office of the Public Advocate seem to offer a middle road between what exists in statute and what's proposed in LD 1025. If it pleases the committee, I would encourage the consideration put forth by Mr. Hobbins' office, specifically the idea that all unused credits be placed in a bank and available to low-income Mainers who are in need of assistance versus the setup that has the ratepayer identifying their own sharing arrangement. In considering the recommendations put forward by the Office of the Public Advocate, we could better align values with practice, encourage and support charity, and not allow our utility to sell the solar power Maine citizens produce on the panels that they own. Thank you for your time. Do all the best as you consider LD 1025.
Thank you very much, Senator. You have about 27 minutes left, so any
Well,
questions?
they'll be looking for me at HCIFS, so.
Any questions from the committee for Senator Brenner? Seeing none, thank you.
Thanks for having me.
You're welcome. We'll now go on to proponents. We'll hear testimony from our public advocate, Barry Hobbins. Barry?
Thank you very much, Senator Lawrence, Representative Berry, members of the Energy, Utilities, and Technology Committee. I'm Barry Hobbins, and I'm here representing the Office of the Public Advocate and here to testify in support of LD 1025. LD 1025 really is, I think, a creative idea that would allow an annual donation from a customer of any unused kilowatt credits to another customer who is served by the same utility. The bill also requires the PUC to review the viability of such a program to ensure there isn't any undue burden placed on the consumer or the utility. If it were the pleasure of this committee, the Office of the Public Advocate would like, if you find it feasible, to explore the possibility of a donation of these credits to nonprofit organizations and or customers enrolled in low-income assistance programs. If the customers were permitted to elect a deposit unused credits into a joint account that could be allocated to customers facing economic hardship. The OPA would even be more supportive of this proposed program. However creative the committee decides it wants to be in the distribution of these unused credits, the Office of the Public Advocate is supportive of the concept and would be ready, willing, and able to assist in any way we can. The office would like to clarify one situation, a potential issue involving the proposed legislation. Currently, NEB credits expire after 1 year. They can be carried for 12 months and then they are gone. Is this bill proposing to do away with the expiration date if the credits are donated, or would the current rules still apply? And hopefully someone could answer that question for us. But we are very supportive of the legislation.
Great. Are there questions from the committee for Mr. Hobbins? Representative Foster.
Thank you, Mr. Chair, and thank you, Mr. Hobbins, for your testimony.
Good afternoon,
I'm
sir.
thinking that I have a question maybe you can answer, or if not, maybe the PUC later. In regards to these credits that expire, how financially, where does that fall? In other words, when that credit expires, how does it affect either the customer that had those credits financially, or the system, if you will, or the ratepayers? Where does that go currently? Thank you.
Sure. Representative Foster, that's an excellent question. I wish I had the answer off the tip of my tongue, but I don't. I would hope that maybe the Public Utilities Commission would have an answer, and possibly one of the sponsor or co-sponsor. I don't have the answer off the top of my head, and I will try to find out, but I don't have it at the present time. But good question.
Any follow-up, Representative Foster? Okay, Representative Cuddy.
Thank you, Senator. Thank you, Mr. Hobbins, for your testimony. I'm intrigued by your idea of a sort of a bank that people could donate to, but would you be similarly supportive of a bank, and yet an individual could also donate their credits to somebody specific? If I had rooftop solar and I knew I had X number of credits into the year, and I knew I had a friend or constituent and I wanted to donate directly to that individual.
Oh, I think it's voluntary. I think it's another opportunity to utilize the low-income fund, a low-income fund. Obviously, that's a suggestion. I'm going to leave it to the committee to be creative or to come up with an idea. That would be probably my preference. I would be happy anyway if whatever you decide to do.
Thank you.
Thanks.
Other questions for our public advocate from the committee?
Thank you.
Seeing none, thank you very much, Barry.
Thanks.
We will now go on to, we'll now continue with people speaking in favor of this bill. And I'll now turn to David Johnson from Buxton. David?
Yes, Senator Lawrence and Representative Barry, members of the Joint Standing Committee.
David, just so you know, there's a little issue with your sound, and we can hear you, but it sounds very echoey. It might be your microphone.
Okay. Is it still echoey?
It is, but why don't you go ahead? We can still hear you.
I apologize for that. I'm not sure how I can improve it. Thank you for allowing me to testify regarding LD 1025. And you've already heard my name from Senator Brenner and your kind words about me, but I appreciate that. For those of you who see my face and think you already know me, you probably don't. My identical twin brother, Chris Johnson, has served previously in the Maine Senate. And he told me I didn't need to come bearing gifts. But he's also testified before various bodies regarding bills for bringing high-speed internet for his community and others in Maine. And but I am David Johnson, not Christopher. Not quite 5 years ago, I invested $20,000 to put solar panels on my roof, along with some heat exchangers and so forth, and doing my part to get to net carbon neutral because what I invested while I was gainfully employed would come back to me during my retirement, which I'm enjoying right now. Thank you. In lower energy costs. I generated about 10.7 megawatt hours in 2020. And since last year was my best year of generation so far, I expect to have about 1.7 megawatt hours expire this year. Up to now, I've had just about that same total, representing $121 in income to CMP. Not a great deal, but CMP makes even more from my solar panel investment, and here's why. I generate most of my power during the hotter months of the year, May through September, and I generated an average of 1.2 megawatts per month during the hottest part of the day through the summer months of 2020. Not only is this saving CMP money by me supplying power to my local area during hours of peak consumption, but it means CMP did not have to pay a premium price for acquiring that power off the grid and using more expensive sources during periods of peak demand. And there's more because, as you know, for the privilege of giving CMP this power they profit off of, I pay them $13.12 per month. It's labeled as distribution, but I do get power from those lines during off-peak and non-daylight hours and on snowy or rainy days, but they get even more power from me during over those same lines delivered at times of peak demand. They should not charge me for the privilege of making them money. And so recently I heard a plug for a Project Heat Telethon raising money to provide heating assistance for low-income Mainers, especially during this past year with all of the layoffs who were struggling to pay their bills. And I donated to that. And that got me thinking, if my energy credits have to expire, why should CMP be the beneficiary of that gift? Because as far as I can tell, it is a gift to CMP right now. It was my investment, not theirs, which generated this power. They already benefit from the peak demand assistance and even further from charging me to deliver them that profit. So why should they get my expiring energy credits? They shouldn't. I'm happy to support those in need in my community in many ways through Project Heat, donations to the Good Shepherd Food Bank, donations to my local Buxton Food Cupboard, donated holiday gifts to children through the Buxton Toy Box. And that's why I've donated my time to coaching softball, mentoring robotics, judging first robotics competitions, Habitat for Humanity, and Equality Maine. And if the energy credits I've paid for with my own investments must expire, I'd much rather they went to support those who need them most in my community. And that's why I'm speaking to you today. As a rightful owner of expiring energy credits, I'm here to lend my support for and to ask that you support LD 1025. Additionally, there have been some discussions about the bill being allowing for these to be registered nonprofits that we make our donations to. I think that's an excellent idea. I like the comments of Mr. Hobbins as public advocate that this be set up similar to current heating support, low-income heating support organizations, and I would be happy to support that. I also heard some comments about
Mr.
this
Johnson,
being.
we do have a 3-minute limit, and you're up against that 3-minute limit.
Okay. Then I'll close by saying I think that the comment about not oversizing in order to be able to generate lots of power, I sized to make sure that I would not fall short. I have never intended that I generate a lot in excess, but the amount that I do, I would like to give to charity, not to CMP. Thank you.
Great. Are there questions from the committee? Seeing none, thank you very much. Do we have, I believe the next person to testify is Ben Grant. Is he on?
I am.
Good. Thank you, Ben. Why don't you go ahead?
Thank you. Senator Lawrence, Representative Berry, members of the committee. My name is Ben Grant. I live in Bowdoin, and about 10 years ago or so, my wife and I decided that we wanted to try to do something to affect our impact on climate change. So we decided to put a solar array on our barn. Speaking of right sizing, we sized the system to cover 88% of our entire household need and put that on over the course of 2 years. It amounted to about 30 panels. And everything worked fine for a couple of years. But we have, at the time, had 2 teenage boys in high school. And when they went to college, who knew how much electricity teenage boys used? And we ended up producing about 108% of what we needed. So for several years, we continued to produce excess electricity and saw that energy go to CMP. We decided that that was not really what we wanted to do. So in 2019, we purchased an electric car to use up the excess that we were generating. And at the time I was commuting somewhere between 350 and 400 miles a week. We quickly used up that surplus that we had and decided that we would add another 18 panels, which was the remaining space on our barn. So we did that in February of 2020, and you all know what happened in March. And since the middle of March, I haven't been to my office in Portland with the exception of a time or two here and there. So now we added capacity to produce an extra 4,500 kilowatt hours to cover our car, in addition to the 2,000 kilowatt hours we were generating in excess. Someone is sharing their screen.
Yeah, I think that's Susan Clary. If you could take that down, Susan. Okay.
Thank you. So, so now we find ourselves in a position where I'm sure, like many, I probably will not be returning to the daily commute, and we'll end up with somewhere in the vicinity of 4 or 5, potentially 6,000 extra kilowatt hours that at the time I did have a right size system, and now due to circumstances beyond my control have all this excess electricity. Given that we live in Maine, where the utility does not have to pay us for the energy we generate, like Massachusetts, it seems to me that it would be a much fairer system if we could donate that. And I love the idea of donating it to a bank for nonprofits or Mainers in need. It would certainly make it easier for us than to have to decide who it went to. I also, in response to the question earlier about tax benefits, we aren't expecting to get any tax kind of benefit from this. We would just rather give it to someone who needs it rather than give it to CMP. So I appreciate the opportunity, and I hope you will all support LD 1025.
Thank you very much. Are there questions from the committee for Mr. Grant? Seeing none, thank you very much, Ben, for coming to testify.
Thank you.
We'll now go on to people testifying against the bill. Deb Hart was going to testify, but she instead has submitted written testimony, is not going to testify today. So we'll go on to Susan Clary from Central Maine Power. Susan?
Okay, sorry about whatever happened there a minute ago. I think as I was getting in the queue here, my machine just kind of went crazy on me. So Senator Lawrence, Representative Barry, members of the Joint Standing Committee on Energy, Utilities, and Technology. My name is Susan Clary. I am the Director of Electric Supply at Central Maine Power Company, and I am here today presenting testimony in opposition to LD 1025. The passage of LD 1711, an act to promote solar energy projects and distributed generation resources in Maine, resulted in the creation of 5 variations of net energy billing agreements. Those options provide greater flexibility and opportunities to and for participating customers. Last week, one of my colleagues spoke with a customer who asked if he could donate credits to his local food bank so that the food bank could then donate the credits to a community member in need of assistance. My colleague explained that while we could not facilitate the donation of credits, the customer is able to modify his existing agreement and add the food bank as a secondary account. Customers can modify their agreements to add or remove off-takers, as well as change the percentage of the facility output allocated to each of the off-takers on a monthly basis. My colleague went on to explain that the food bank would then receive kilowatt-hour credits on their monthly bill. The savings that the food bank receives from the credits applied could be monetized to provide direct assistance to community members, either through food or financial assistance. The customer was happy to hear about the options and thanked my employee for the information. He indicated that he would be back in touch with us to modify his existing agreement and take advantage of the opportunity to provide benefits to his community. As noted in my pre-filed testimony, I have serious concerns with the inequity that could arise in the wholesale energy market if customers were allowed to donate credits. Existing standard offer and competitive electricity providers would be charged for more load in the ISO New England wholesale energy market than the amount of consumption billed to the end-use retail customer. This could lead to less competition in Maine's deregulated energy market, as suppliers would have no way to mitigate this risk. Lastly, I raised concerns with the time and costs associated with developing modifications to the utilities billing systems to accommodate LD 1025. As there are options already available to customers to help mitigate and manage help manage the allocation of output from the generating facilities in order to mitigate the expiration of unused credits, spending ratepayer money to perform costly upgrades to the billing system is not necessary. Thank you for your time and attention. I'd be glad to answer any questions that you may have.
Great. Are there questions from the committee? Representative Grochowski.
Thank you, Mr. Chair. Ms. Clary, I'm curious, I seem to recall that there's a limit on the number of meters that could be associated with an account. That's my first question. My second question is something like the food bank that could be associated with a customer's account. What do they have to do on their end to sync up with a customer? And, you know, what if they are trying to sync up with like 100 customers? It seems maybe there could be a more efficient process. There's two questions there.
Okay, the first one is with LD 1711, that limit that you just were talking about in the last bill went away in CMP and the former Bangor Hydro territory. So prior to LD 1711, there was a limit of 10 off-takers from an existing facility. Now it's unlimited, and we're really seeing hundreds and hundreds of off-takers, secondary accounts listed on a facility. And we actually have some project sponsors that every single month they're adding or removing off-takers, and they're changing the percent allocation to the various off-takers. So we're actually seeing the benefits of 1711 already being put in place by people managing who the off-takers are. And then, excuse me, the second part of your question again, please.
So for the person who would be the recipient of the credits, what sort of effort do they have to make on their end to sync up with the supplier of the credits?
Well, in this case, the community food bank, if this customer who wanted to add that community food bank to his existing net energy billing agreement, that food bank would be able to see how many credits he's receiving each month, and they could see the savings that the food bank itself was receiving off in its monthly energy bill, and they could monetize those credits, and then they could either purchase more food for distribution in their community, or they could monetize those credits and actually use those credits as financial, cash to give to customers when they come in for their food bank. They could give them some money towards their electricity or whatever else bills that customers might have trouble paying at that time.
My question, if I may, Mr. Chair, was actually, what do they have to provide? An account number?
Yes, I'm sorry about that. Yes.
Yeah.
Okay. Yes, we would just need to have the account number that the existing, facility owner. They would have to get the account number of the additional customer that they want to add to their net energy billing agreement.
Follow up, Representative Grahowski. Okay, thank you. Representative Foster.
Thank you, Mr. Chair, and thank you, Ms. Clary, for your testimony. Maybe you can answer a question I had earlier for Mr. Hobbins. I'm wondering if you could explain if credits expire, where that financial piece goes when that happens. In effect, where does it end up as a credit or?
Okay, the way that the ISO New England wholesale energy market works, the month that the generation is produced is the month that they get reported to ISO New England. So in the case where it's kilowatt hour credits, whoever is the supplier of the customer or customers, the total amount of the generation in over a calendar month is used to reduce that suppliers, that competitive supplier or standard offer suppliers load in the ISO New England wholesale energy market. So it's really the suppliers that are using that money in the month that it's generated. They get basically a credit from ISO New England because their load is reduced. And then as the customer withdraws that energy from their bank over the next rolling 12-month period, and the customer's retail invoice is reduced in each of those periods that they have to draw from the bank, then that competitive electricity provider or standard offer provider, the retail revenue that they receive from that customer in a subsequent month is reduced. So it's really the suppliers of the energy that are seeing that benefit of the energy in the month it's produced, and they're really the ones that are seeing their load in the ISO New England market reduced. So it's not a T&D savings. We don't take that excess generation. We don't use it for our own accounts. We don't resell it. We don't monetize it in any way to benefit from that because it's all done through the ISO New England wholesale energy market settlements.
If I may, Mr. Chair.
Yes.
So I just want to make sure I understand clearly. It's not CMP as some would think, and as a lot of us would that get our bills from CMP or Versant, that it's your company or Versant that's actually getting the money from not using those credits. It's actually the energy supplier. Is that what you're saying?
That is 100% correct. Yes.
And when that energy supplier gets when those credits expire, that energy supplier, are they probably seeing that as a potential profit, or does that actually help out other ratepayers who are buying energy through them?
Again, the month that the credits were generated, that's the month that the supplier sees the full benefit of all of that generation. And then you're right, if the customer doesn't draw those credits down in the subsequent 12 months, then yes, then that supplier could end up with a windfall for serving that particular customer's load, which they never really reduced the retail revenue, even though they received the wholesale credits in the ISO settlement market. So yes, it is the supplier that would potentially could get a windfall in that situation.
And if I may, one more, Mr.
Go ahead,
Chair.
Representative Foster.
So again, just to be clear, because this is not what I had thought, I don't think, on how this works. In that case, none of that money goes to the ratepayers or in any form, much like our mains bottle bill. If the bottles don't get returned, other customers don't get the money. It's sort of a windfall. And is that correct?
You are correct.
Thank you very much.
Any other questions from the committee? Seeing none, thank you very much, Susan. We'll go on and continue with people we're going to go on to people testifying neither for nor against this bill. And I'll now turn to Garrett Corbin from the Public Utilities Commission.
Okay, thank you, Senator Lawrence, Representative Berry, members of the committee. Again, Garrett Corbin testifying neither for nor against this legislation. Our testimony, just real quick in case I don't make it all the way through it, is that our rules do currently allow for this. And then as CMP just explained, they have a process that allows, I shouldn't say this, it's, the mechanics are a little bit different, but there is a way to designate someone to receive your excess energy, as was just explained. So Section 1 of the Act would amend a net energy billing statute to allow customers with a NEB arrangement to annually donate any unused kilowatt hours to another customer, as we've discussed. And then Section 2 of the Act would require the Commission to conduct a review to determine if it is unreasonably burdensome for a small number of residential customers to create a shared financial interest for net energy billing purposes. Among the changes to Maine's NEB law made by the prior legislature was the new shared financial interest requirement. It includes facility ownership, lease agreement, or a power purchase agreement. And the Commission's rules adopted pursuant to the Act contain provisions regarding shared financial interest customer facilities. That rule also contains provisions that allow for transfer of a financial interest to new or additional customer accounts. Under the NEB rules, consistent with the prior NEB rules, excess credits can be used to offset kilowatt hour usage over a 12-month rolling period. And then at the end of the period, those unused credits expire. And that's been the subject, I think, of Representative Foster's questions. So Section 1 of the Act would allow customers to arrange to annually donate those unused credits. Because the sharing arrangement can be changed on a going forward monthly basis, a customer currently has the ability to share or donate credits on a monthly basis. Also in the bill, would likely create a significant burden for the utilities to require manual billing or billing system upgrades, but that's something that we defer more to the utilities for their technical perspective on that. But we did raise the question as to what's gained by amending the statute to allow for the donation or transfer of kilowatt hour credits at the end of the 12-month period, when the allocation can be adjusted anytime to account for any expected excess credits. And then we also note that the approach in this act is further complicated by the ISO New England wholesale market rules, in which the supplier's load obligations are accounted for on a monthly basis, as was pointed out previously. Moving the credits from one customer to another at the end of the 12 months could probably impact individual supplier load obligations and create uncertainty in the supply markets. Finally, the Commission notes that this act uses the term donate, and that typically refers to a provision of something of value to a nonprofit organization. I think I heard the sponsor acknowledge that in his testimony. So we just wanted to note that you might want to clarify that depending on how this turns out. And then just a few observations on the second section of the act. The Commission would be required to evaluate whether the provisions are clearly written and understandable. The Commission's not aware of any concerns regarding the language or operation of the shared financial interest provisions of its rules. And because the Commission can consider and resolve such issues through processes that would involve all stakeholders, and in light of the Commission's limited resources and additional work likely coming down the pike, the Commission respectfully requests that the committee attempt to prioritize directives for Commission reviews and reports. And with that, I'd be happy to take any questions. We will be present for the work session, and thank you for enduring such long testimony.
Great, thank you very much, Mr. Corbin. Question from Representative Cuddy.
Thank you, Senator Lawrence, and thank you, Mr. Corbin, for your testimony on it. And it sounds like from what you've said and what Ms. Clary said that we can indeed, on a monthly basis, if you have rooftop solar and you want to assign somebody to receive excess kilowatt hours, that can happen now. Am I correct in that, or am I misunderstanding?
No, that's correct, as long as it's done in advance. So you just, yeah.
So if we were to have an entity similar to the one that OPA Hobbins suggested, of some form of a bank that could receive these, would it be how much different is that to have a bank that can receive them as opposed, and an individual can say, yeah, I want to give it to this bank, so low income folks or people who are having problems paying their bills can access those.
If you just, off the cuff, I suppose if that bank had an account, then it could just be an account that's designated, but I don't want to get too ahead of myself. So we can try to answer that better for a work session. And then I defer probably to the OPA and the utilities themselves too, for maybe more on the mechanics of that, but sounds theoretically doable to me, but don't hold me to that.
Sure. I thought of the question, unfortunately, after Ms. Clary was done, and I see Mr. Cody in the wings, and I'll just leave it out there for Mr. Cody that he understands that I will be asking a similar question of him.
Any other questions for Mr. Corbin from the PUC? Seeing none, thank you.
Thanks.
We'll now go on to James Cody, representing Versant Power. James.
Thank you, Senator. Representative Barry, members of the committee, thank you for indulging me on a few occasions. Versant Power is here today to testify neither for nor against this legislation. I would just note three quick considerations. One is it would be helpful for us to know, and we could probably get to this number in terms of what we anticipate for the number of customers and the associated costs with these program changes. Understanding how many customers might be interested in this sort of program would probably dictate what we anticipate for a cost to upgrade billing systems to allow for this. The second piece of this, and Representative Grochowski pointed this out earlier, is that we did want to point out that properly sized systems are important, and they are more unlikely to produce large amounts of unused credits. And obviously, as one of the gentlemen earlier pointed out, sometimes you just can't control that. When you've got two teenage boys that leave the house, sometimes you'll have ample generation there that you just can't do a whole lot with. And then lastly, just wanted to point out, from a timing and priority standpoint, obviously the committee has engaged in a subcommittee process where we're now talking about NEB and what that program is. And so we would just ask that if we're going to really look at this change going forward, that maybe we incorporate it into a future vision that's predictable going forward, so that we can plan on this and make a decision about the changes necessary in billing systems with all the other changes in mind. And that said, to Representative Cuddy's question earlier, I'm happy to respond to that, but I think I'll need to circle back with the company to sort of do a bit of a deeper dive that front before I can answer with any detail, but I'm more than happy to do that.
Great. Are there questions for Mr. Cody? Yes, Representative Cuddy.
Thank you, Senator, and thank you, Mr. Cody. I look forward to getting that. And sort of to add on top of that, the bill envisions a once a year donation. But would it be something that might be simpler for the company if we were talking about a monthly donation where there could be this account that it could be placed into? I don't expect you to know the answer to that off the top of your head. If you could just add that into your thinking as you're looking at the other question.
And just to clarify on that, Representative Cuddy, you're talking about an election where the customer could basically say, if I have unused credits, please send it here on a monthly basis.
So it would be a prospective allocation that they could make before those hours ever came to be, and they could donate those hours, and you would already know beforehand where they were going. So I'm interested to know if that would necessitate the same billing upgrades that both you and Ms. Clary have spoken about.
Sure, happy to dive into that, and we'll provide a response in advance of the work session.
Any other questions from the committee? Seeing none, thank you very much. And we have one late add-on, Chuck Piper. Chuck, are you there?
I am here. Thank you very much, Senator Barry and committee, for allowing me to testify on this bill. I'm excited to see this bill and get to speak about it. It's near and dear to my heart. I'm one of the owners of Sundog Solar. We're located over in Searsport, and we have 30 employees that work for us. We've been in business now for 11 years. And approximately 3 years ago, when we were in the dark times for solar in this state, we were looking for any positive way to move our opponents. And one particular opponent I recall was Jeff Hanley. He talked about his constituents were poor and they needed assistance. And so I suggested that we take all these excess kilowatt hours that are being generated every year and donate those to people in need. And so that's why I'm thrilled to see this bill come about. And as far as I'm concerned, it's a chip shot because every month CMP generates statements to all the solar customers that tell them what they've got in the bank and what's about to expire. And so each month credits expire, and that's on a spreadsheet. They can just take that, summarize it all, and put it into one account, and then those can easily be distributed to people that are going to be shut off, or anybody in need. Now, it's been said that there's processes in place that will allow people to donate their credits. Well, yeah, there are some processes in place, but they're unwieldy. You have to fill out a form, and you have to get the account number for the person you want to send your excess credits to. And if anything changes, then you've got to resubmit a form to redact that and not allow that to happen anymore. And so it's just a little unwieldy. I think we could simplify the process. And so anyway, I'm all for this bill. It's very positive. Thank you.
Thank you very much. Are there any questions from the committee for Mr. Piper? Seeing none, thank you. Jordan, have I missed anyone else who wants to testify on this bill?
That's all I have. So I think
Okay,
we're all
great.
set.
I'll declare the hearing on this bill closed. And again, I'll just remind people listening to please try to sign up the evening before if you want to testify, simply because it makes it easier on us and on Jordan especially to organize our hearing session. We have our final bill to go on to. And Jordan, I'm not sure if we have the sponsor here yet, Senator Whitsom.
I just made him a panelist, so he should be on now.
Great.
I'm here.
So we are now going on to LD 1100, an act to support continue access to solar energy and battery storage by Maine homes and businesses. And the chair is pleased to recognize a former member of this committee, who I'm sure will be sending us treats at some time, which is the tradition, Senator David Whitsom. Senator.
Thank you, Mr. Chair. And I hope you all have big pickups because it's in the mail. Senator Lawrence, Representative Barry, and distinguished members of Energy, Utilities, and Technology Committee. I appreciate you taking the time to consider this bill, LD 1100, an act to support the continued access to solar energy and battery storage by Maine homes and business. While serving on this committee in 2019, I supported the passage of legislation to increase the use of solar in the state. One of these bills, LD 1711, was intended to accelerate smaller scale solar projects that provide clean energy for Maine homes and business, and which support good paying jobs in Maine. The success of that bill in attracting new projects and capital investment to our state has been well documented. And your committee is considering several bills this session to revisit the program based on that success. But the new solar programs have not been without their challenges, including in particular some of the challenges the state investor-owned utilities have had in responding to the volume of new solar interconnection requests so that those projects can connect safely and reliably to the grid. While much of the attention surrounding the utility interconnection costs, delays in utility areas has centered on larger solar projects owned by developers, I've been particularly concerned by reports that these same issues are also affecting main ratepayers seeking to install solar to offset their own electrical usage. As a result of the large volume of new solar projects proposed overall, some main homeowners and business are being caught up in the same costly delays for utility upgrades that affect larger projects. Additionally, local solar companies that have been the backbone of the state's industry have been seeing significant disruption in the solar markets that existed prior to 2019. To date, this disruption has largely been experienced by commercial projects. This is particularly concerning since a key provision of LD 1711 was to remove barriers for main business to access the benefits of solar energy. The manner in which the utilities has been handling these types of projects has created new bureaucratic red tape that has created unnecessary delays and have deterred customers who are unfamiliar with utility rules or for whom engaging in technical processes with the Public Utilities Commission is either too costly or too confusing. A striking example of this issue was experienced with a project in northern Maine for the heuristic ban of micmacs. After submitting an application to interconnect the project, the utility concluded that the project would need to be treated like a much larger project, even though it met the fast track provisions outlined in the state's interconnection rules. The project installer, a small electrical construction firm based in Fort Fairfield, advocated on behalf of the Micmacs with the utility and the commission. Eventually, the contractor had to hire a regulatory attorney and incurred significant and disproportionate expenses to convince the commission that the utility was not properly applying the rules. This is a single example that is emblematic of several small projects across the state that are being treated inconsistent with existing rules, which indicate more significant challenges for main homes and business wishing to invest in solar projects in the future. The utilities have claimed the rules are as written do not adequately address the needs of the utility grid. The commission has a docket open in an attempt to resolve these issues. If this issue is left unaddressed or improperly managed, it threatens to affect much smaller projects and ultimately make it all but impossible for homeowners or business to build their own solar projects. Because Maine uses a first come, first served approach to interconnection, a Maine homeowner will be required to pay hundreds of thousands of dollars to make major upgrades to the utility grid in order to install a small rooftop solar system simply because a larger project happened to be proposed on the same circuit and consumed all the available capacity. The legislature has an important role in this matter to ensure that the commission has sufficient guidance on the state's priorities related to these issues and to ensure the commission has the necessary resources to deliver upon these priorities. This bill seeks to resolve these challenges in a timely manner with two specific actions. First, it provides explicit guidance in statute to the Public Utilities Commission regarding the commission's responsibilities related to interconnection rules for solar energy systems. This guidance includes using lessons from other states to address the interconnection of Maine's growing solar capacity to our electrical grid and providing protections to utility customers to ensure they do not assume an undue burden due to deficiencies in the state's interconnection rules and utility infrastructure. Secondly, it provides funding to the commission to hire a qualified consultant to immediately address existing issues related to the interconnection of solar systems that are negatively impacting Maine small business and threatening millions of dollars in investment. It's been 2 years since this legislature passed a series of bills to increase our utilization of solar energy. As a legislature, we need to ensure that the implementation of our previously enacted legislation is consistent with the legislative intent. In this case, we need to enact LD 1100 to protect access for Maine residents and Maine small business and to reduce red tape for companies serving these customers. Now, I believe also with my testimony, further language was submitted to you folks, and I think you have it. And some folks following me are better prepared and knowledgeable on addressing the additional language. So thank you for your time, and I appreciate your patience, and God bless all of you.
Thank you very much, Senator. Are there questions from the committee for Senator Woodson? Representative Berry.
Thank you, Senator Lawrence. And I actually don't have a question. I just want to say, Senator Woodson, it's great to see you. Senator Woodson, for those who were not with us then, was the chair of this committee for, I believe, 4 years. I was privileged to serve as his co-chair for 2 of them. And I think served a total of, I don't want to date you, but maybe 6 years on this committee. And it's great to see you back, Senator.
Well, you know, I got a great education on EUT, and they advanced me to the education committee. So it's good to see you too, Seth, and the rest of you.
Now, having been chair, Senator, doesn't that mean you have to bring extra large treats?
I think it does. And as I say, I think FedEx will be at your door shortly.
Good.
All right.
Great. I don't believe there are any co-sponsors to testify on this bill. So thank you for coming, Senator, and we'll go directly on to Stephen Weems of the Solar Energy Association of Maine.
Okay, thank you all.
You're welcome.
Thank you, Chair Lawrence, Representative Berry, other members of the Joint Standing Committee on Energy, Utilities, and Technology. I'm still Steve Weems, Executive Director of the Maine Energy Association of Maine. And I found a wedding present recently. It's a sterling, what do you call this? Anyway, it's a timer. And it's supposed to make the perfect egg, so it's 3 minutes. So now I'm all set. It's always a pleasure to work with Senator Woodson on solar matters. Therefore, we are really happy to offer our strong support for this operationally necessary piece of legislation. We've submitted written testimony this time ahead of time as we're supposed to, and I'm not going to repeat that. Others will be have more field experience than I do on this that hopefully will follow, and Senator Woodson's testimony is far better than mine. So I invite you to reread that at least a couple of times. It really hits the high points. There is an interconnection quagmire. It's been kind of well documented. The guts of what this bill would do that is in that arena is to deal with the problem of small projects getting interconnection applications processed and approved. They're supposed to be fast-tracked, and they're getting all ground up in a process where they get aggregated with bigger projects, and it's just a complete mess. You've heard a lot about that, and I won't dwell on it. The PUC is working on this. They have the docket you heard about, but this is really not good enough because it means that the issue is getting tied up kind of interminably in administrative proceedings. And quite frankly, the PUC is a little bit passive on this issue and being too deferential to the investor-owned utilities who have their own reasons and problems in processing these applications. So why is this really important? Given the fact that the PUC is already working on it? Well, the senator had good points about that in his testimony. This is a case where really well-intended policy gets derailed by just operational problems in implementing it. And the bill will kind of cut through that and create a clearer mandate for the PUC, will require them to learn more about best practices, and is more prescriptive about the character of a good solution of this, and sets timetables and accountability measures. So it's really good government legislation to solve a real serious operational problem, kind of impeding smaller solar projects. Thank you.
Thank you very much, Steve. Are there questions from the committee? How'd you do with your egg timer?
There's about 10 seconds left to go.
Great, appreciate it. Super, we'll go on to our next person testifying for this bill, Vaughn Woodruff from Pittsfield.
Hi, Senator. Good to see you. Representative Barry, other distinguished members of the committee. My name is Vaughn Woodruff. I'm broadcasting from lovely Pittsfield, Maine. I'll be happy to take Steve's extra 10 seconds if I can. I've been in front of you in a number of capacities. I'm the former CEO and founder of InSource Renewables. I've also been in front of this committee as the former chair of our industry trade group. I'm now InSource joined forces with Revision Energy in February of this year, and I'm now directing workforce development efforts there. I'm here with my industry hat on behalf of our homegrown solar companies. I've spent a lot of time with committees and entities I never knew existed when I entered the solar industry. And we've been in the weeds on a lot of these. I've been heavily involved in the issues addressed in LD 1100. You know, former trade group associates constantly call with regards to the issues that they're having. And what has been happening over the last 18 months has been significantly challenging and threatens to grind our industry to a halt. We've seen that happen with larger projects, and we're now seeing it with projects that existed prior to 2019. I took charge with the gross metering proceedings, spending time in front of the commission during those, and that's helped me to be a resource for other companies in the state on this matter. Those lessons, I can tell you that the issues that are happening now are a bigger existential threat than the gross metering proceedings that we went through. And for those of you who've been involved in the gross metering discussions, know that that's not a light statement to make. But essentially is what has happened is that the amount of time and resources, which has been immense, that's been needed by the PUC and by the utilities to quickly adapt to a fast changing environment, have put a lot of projects in limbo. I point to testimony from Chief Peter Paul from the Aroostook Band of Micmacs that I believe was submitted yesterday. The contractor that worked with him, Todd Maynard of Maynard Electric, was hoping to be here today, but coincidentally had a meeting with his regulatory attorney on an issue with another project that he's having similar challenges with, in which Versant submitted a request for an advisory ruling on yesterday. The issues we're running against aren't unique. Other states have dealt with them. I reached out to Interstate Renewable Energy Council's lead regulatory attorney, and we're running up against them. We've got to figure out how we allocate costs of system upgrades and how we prioritize projects. I would say that, you know, when the bills passed 2 years ago, the goal was to build upon the work of our homegrown solar industry, not to supplant it. Our small companies don't have the ability to shift into another state when we see backups in regulation. We have to deal with what's around us. And if we have a quagmire or a blockage like this, it threatens those small businesses. And there are companies that are trimming back their activities in spaces they've done work before as a result of this. So this bill does two things. One, it helps the legislature kind of fine tune its guidance to the commission, so the commission is clear on what the legislative intent of solar policy is by building on law that was passed by good Senator Vitelli a number of years ago, the Maine Solar Energy Act, and clarifying that. The second thing it does is it brings an expert.
To let you know, you're a little bit over the 3-minute limit.
Okay, I'm going to wrap right now, Senator, if that's okay.
Yep.
The second piece is to give the commission the resources and the expertise that can come in and help resolve this in a timely manner. So I appreciate your attention to this issue. I'm happy to answer questions and hope that you all will support passage of this fundamentally important bill for our industry.
Thank you very much. Are there questions from the committee? Representative Berry.
Thank you, Senator Lawrence. Vaughn, it's good to see you. You've appeared before this committee over many years. And I know you've spent a lot of time working on this, as the CEO of InSource Renewables. InSource Renewables, my understanding, was a small business, was based in Pittsfield. Were you compensated in any way by others in the industry for your time, all that time you put in at the PUC or at the legislature?
I probably wouldn't be here in front of you right now if I had been. No, not at all. I mean, that's what's ended up happening a lot of times, is that our small businesses have been forced to fill in the gaps that we have, right? A lot of these larger projects are owned by the developers, right? So they have it built into their business models to take on the regulatory costs there. The pieces that happen with gross metering, in which we had spent, we probably spent $50,000 of resources to help make sure that we could continue to do business during that time under the new rules. That came as somebody needed to deal with it. Todd Maynard with Maynard Electric has been in that. He was kind of the tip of the spear with the project he's working on. It's an issue. There's a physics issue there. There just isn't an entity at the table. Ultimately, that relationship is between the utility and the customer. And what's had to happen is that we've had to come in and advocate on behalf of those customers, and we can't build those costs into a project because the project can't happen. So a lot of it's been altruism. There's definitely some pieces there to make sure that our industry is still able to move forward, but it's usually the last, the person who's most affected, everyone else steps back and they have to step in and take on those costs and resolve those issues.
And if I may, a follow-up.
Representative Berry.
Thank you. So, I know, Mr. Wood, you started the Solar Energy Association of Maine with a number of other smaller installers. Steve Weems, who spoke earlier, he's always introduced himself to us as the volunteer, unpaid executive director. Really appreciate the time that he puts into these issues as well. But I guess my question really is about is there an inherent challenge in working at the Public Utilities Commission and at the legislature and with the utilities to address these interconnection issues and the different regulatory issues for a small installer that's maybe just a guy or a couple of guys with a pickup truck?
Right.
Is that part of the imbalance?
Yeah, it's challenging, right? So, as you've seen on this committee, we're making a very dramatic change in the structure of our public utilities and ways that our electricity is generated and delivered. And so the utilities, right, they have regulatory staff that are there. They're paid to be there. They need to be there. It's appropriate that they're paid to be there so that they can, be knowledgeable and provide input. Commission staff's there for that. There really isn't an entity to support future generators, right? Or, customers that don't have the technical basis. It's a technical process. The commission, it's a steep learning curve. It's formal, it's fact-based, which is great, but it also means going back through years and years of dockets to understand what rulings led to what, and at times to help refresh commission staff who are dealing with a lot of various things on matters from 12 months before. So there's a heavy burden, and there's really not anybody in the state right now set to fill that. Public Advocate's Office might be that, but their staff is, basically working with folks who need their assistance. And there's a bit of a gap that exists as a result.
Thank you.
Great. Are there other questions from the committee? Seeing none, thank you very much. We'll now go on to the next proponent, Fortunat Mueller from North Yarmouth. Fortunat.
Thank you, Senator Lawrence. Representative Barry, members of the committee, my name is Fortunat Mueller. I'm co-founder and president of Revision Energy. I'm here today to testify in support of LD 1100. Your committee has heard before from the commission, from the utilities, and from the solar development community about some of the challenges that are affecting larger solar projects with respect to interconnection costs and timelines. As the sponsor noted, those same challenges are starting to affect smaller projects in Maine as well. And while it's a big deal for any project, the challenge is particularly acute for the smaller projects, the individual customers, for a couple of reasons. One, the costs involved are often wildly disproportionate to the project size. Though not from Maine, we have an example of a residential customer in Massachusetts, for a $20,000 solar project who was asked to pay a $250,000 utility upgrade bill. And it's obviously sort of just patently ridiculous on its face. And as Vaughn just mentioned, the other big challenge is that the utility process and the Public Utilities Commission process are not set up for lay people. And so customers find it difficult to navigate those processes. They're not particularly customer friendly. And that's a real challenge for even the most stubborn Maine customers. And we do have a lot of stubborn customers who are willing to go to the mat for their projects when it often doesn't make sense. And then finally, one really important distinction between these projects and the developer projects is if you're a small business somewhere in Maine and you apply for interconnection and you get back a really unfavorable result, you don't have the choice to just pick up and do the project somewhere else, right? Your business or your home exists in a particular geography, and your interconnection costs are essentially a consequence of the historical choices of the utility in terms of investment, good or bad. And so it's kind of like rolling a dice. And unfortunately, the dice tends to be harshest to the customers in the rural parts of our state, where the utility system is the weakest. And so that's a real challenge in terms of fairness and equity, in terms of the ability for customers to participate in solar around the state. Though there's lots of issues with interconnection, as you've heard, the most significant challenge is around cost allocation. I just want to briefly, I think you guys understand, but I just want to briefly explain how this works. When in Maine, when a project proposes to interconnect on a particular circuit, if there is capacity on the circuit, which there usually is, the project interconnects essentially for free. And up until the capacity is used up, those projects all interconnect for free. Then suddenly when you hit some threshold that is driven by the size of the wire, or the size of the transformer, or whatever's upstream, the next project in has to pay for that whole incremental upgrade. So in practice, what happens in the development environment we're in now is the larger developers who are smart hire engineers to figure out how much capacity is available, and they size their projects. And I should say, we do the same thing when we're doing larger projects, right at that limit. So if there's four megawatts left on a substation, we will build a 4 megawatt project. Then the residential or the small business customer who shows up next is the triggering project. Now they carry the burden of the upgrade, which obviously doesn't work and doesn't make sense. So we're increasingly seeing circuits or substations around Maine that are quote unquote full, where the capacity is fully reserved by projects in the queue. And that means whole towns, whole neighborhoods, there is no longer an option for businesses or residential customers to go solar without being the triggering project.
You're up to your 3-minute limit.
Okay. I will just say, a bunch of the recommendations in this bill mirror recommendations that we've made in the ongoing PUC docket. And I think the PUC has the authority to do a lot of them unilaterally. I think they probably will not, and they could use a nudge from this commission, from this committee. I'm not criticizing the PUC. I think they've had their hands full this past year, but I think they could use a policy nudge from this committee and the legislature if you guys believe that Maine businesses and customers ought to continue to have the ability to invest in solar. So with that, I will welcome any questions you might have. Thank you.
Great. Other questions from the committee? Representative Barry.
Thank you. Thank you, Mr. Mueller. You know, I'm fascinated by the question that this bill asks in paragraph C, I think it is. You know, that tries to get at what you're talking about, that issue of, you know, who pays. It's 3C. Investments are coordinated with utility infrastructure upgrades, and you've really helped us to understand that issue better. But you've always described it from the generator side, and I'm just wondering, isn't there also, as we look to adopt more heat pumps and use more EVs and, you know, use more of this load, likely to be a need to upgrade that infrastructure soon anyway? I mean, what can you speak about that side of the equation a little bit?
Yeah, thank you, Representative Barry. It's a really good question. Yes, much of the grid will need upgrading for beneficial electrification as well as for distributed generation. And in many cases, those upgrades are the same, and in some cases they are distinct. One of the reasons we believe that behind the meter small solar that is co-located with load, it should reasonably be treated differently than standalone projects out in the field somewhere, is because they are in the same places as load is likely to grow as beneficial electrification happens. So the chances that the upgrade that is paid for to accommodate a solar project today will also be useful to accommodate a residential EV charger tomorrow is much higher in those cases than if you're building out in the field somewhere. And some states have moved to cost allocation, modernized cost allocation rules that recognize that distinction and charge projects different sizes differently, and charge projects where upgrades are likely to have other benefits differently, and do the same thing that they would do if the EV charger was the triggering upgrade, which is to socialize those costs rather than make the individual customer bear them.
Thank you.
Any other questions from the committee? Seeing none, thank you. We'll now continue with proponents with Melissa Winnie from the Governor's Energy Office. Melissa?
Yes, thank you. Good afternoon, Senator Lawrence, Representative Barry, members of the Energy Utilities Technology Committee. My name is Melissa Winnie. I'm the Energy Policy Analyst with the Governor's Energy Office. The Governor's Energy Office today testifies in general support of the concept of LD 1100. For some context of interconnection as a whole, as you likely read upon reports of the significant cost changes related to CMP's interconnection agreements, Governor Mills did send a letter to the Public Utilities Commission in February of this year to open an investigation into the genesis of the problems reported, specifically related to CMP. And additionally, in the letter, there was a request to initiate a broader review to ensure that Maine's electric utilities have the systems and planning in place to accommodate the growth of renewables and distributed energy resources as relates to interconnection. And as has been mentioned, following that letter, the PUC did initiate various proceedings in addition to existing interconnection-related initiatives. And we are monitoring and in some cases engaging in those proceedings already underway at the PUC. And these include an inquiry anticipated to inform an upcoming rulemaking to modify the Level 2 interconnection process, as well as other multiple recent requests for advisory rulings. You know, the Energy Office would like to emphasize the importance of interconnection in order to meet the state's clean energy and climate goals, and recognize that clear, consistent, and timely interconnection procedures are a key component of developing renewable energy projects. And while primarily the interconnection challenges of some of the larger distributed generation projects have been highlighted, as has been recognized here, the smaller distributed generation projects are also facing considerable challenges and must be addressed. We do request to hear from the PUC regarding their ongoing interconnection proceedings. We're trying to better understand if there are, in fact, gaps between those efforts and what's requested here in this legislation. to help better understand if this is needed. But again, we do support the efforts around interconnection as a whole. And one thing we would request, if the committee does move forward with this bill, we would recommend in the section 2 of the bill to broaden the language a bit to include all renewable technologies for that section of the bill, the study section. So thank you for your time and consideration. And as always, I welcome any questions.
Are there questions from the committee? Seeing none, thank you very much. We'll go on to Chuck Piper testifying in favor.
Thank you, committee, for allowing me to testify before before you and discuss this bill. I consider this bill emergency legislation for our business. As I mentioned earlier, we employ 30 people here at Sundog Solar, and we had hoped with LD 1711 to be able to hire more mainers to install solar, and hiring is not proceeded as quickly as we thought it would, and we're actually concerned, about retraction now that all the facilities have been taken up by the out-of-state developers. As a real world example, we just received notification this morning from Versant that a 65 kW system in Ellsworth has failed the technical screens because the substation is overloaded, and now they want to bump us up to a level 4 application, which puts our small project in direct competition with 5 megawatt projects. Those are 10,000 panel systems that have tied up the facilities so that we can't proceed with smaller businesses. Now, this particular customer up in Ellsworth is excited to do his part to put up solar panels, and I'm going to have to tell him that we aren't going to be able to do that until something changes. So there's that piece, the employment piece, and the fact that customers are not going to be able to install their systems, main customers. And then the next big thing is LD 1711 finally allowed customers that have demand charges to get those offset with solar. Well, demand charges occur with higher usage customers. Now they're in the boat where they can't even take advantage of offsetting the demand charges because the facilities are full. This particular example up in Ellsworth, I was told that the substation has 12,000 kilowatts of reserved solar in the queue, and our little project is 65 kilowatts, and that would employ a half a dozen people for a couple of weeks, and now it's at a standstill. And so I consider it emergency legislation. We're gonna have to backtrack now and probably concentrate on level 1 applications, which are just small residential projects. And as well as I do, we need to get as much solar installed as we can with the climate the way it is. And, we had hoped to install larger projects. So I hope that you'll treat this as the emergency that we see it as, and I wish you the best.
Thank you very much. Are there questions from the committee? Seeing none, thank you. That completes people testifying in favor of this bill. We'll go to people testifying against this bill, and I'll recognize Stephen Hudson. Steve?
Thank you, Mr. Chair. Senator Lawrence.
You froze, Steve, and then we lost you. We got your back, Steve.
Okay.
Okay, good.
I won't take it personally, Senator. Senator Lawrence, Representative Berry, members of the Energy Utilities Technology Committee. I'm Stephen Hudson. I'm a partner with Pretty Flaherty Law Firm. I'm here today on behalf of the Industrial Energy Consumer Group in somewhat reluctant opposition to LD 1100. We know how frustrating interconnection can be. Because all of our members are interconnected, whether they have on-site generation or not. They've had to work through it. They've had to pay for any upgrades. They've had to pay the cost of their interconnections. Our concern with this bill is, one, I think we've heard multiple people say on earlier bills, well, the PUC's already got too much to do. Well, the PUC is already underway in looking at these issues, these interconnection issues in Maine now and for the future. And it seems to me if there are specific concerns that this legislation proposes the PUC should address, it would seem far more appropriate for the committee to be sending a letter to the PUC to ensure that those concerns are addressed. But more importantly than that, for the IECG regard, is that we're not sure that everyone's been candid with you today, because there's been a lot of discussion about the costs of interconnection. But only one person that I've heard so far has actually used a phrase called socializing the costs. And what that means is the ratepayers are going to pay. Now, they already pay in premium rates for the distributed generation and the renewables. They already pay for compliance with Maine's renewable portfolio standard. And the owners of these projects not only get federal tax credits, but in many cases, they get state tax credits or other beneficial tax treatment, either at the municipal or the state level. But to now suggest that ratepayers should also pay the costs of interconnection is now at a time when the PUC has predicted that this explosion of solar is going to result in a 28% increase in rates is irresponsible. Yes, we should try to figure out a way to coordinate. There are many things that some of the proponents have suggested that the PUC is likely to address, and many of those folks who have spoken are likely to participate in the PUC's examination of the issue. But we need to be looking at how we're going to accomplish these important tasks without always going to the ratepayer and having them pay. Thank you. We'll be glad to be here at the work session to answer questions and look forward to working with the committee on this legislation.
Thank you very much, Steve. Questions from the committee? Seeing none, thank you. We'll now go on to people testifying neither for nor against, and I'll recognize Garrett Corbin from the PUC.
Good afternoon. Once again, Senator Lawrence, Representative Berry, and members of the Energy Utilities Technology Committee. And for the last time today, Garrett Corbin, testifying neither for nor against LD 1100 on behalf of the PUC. I won't say who, but I did see one of the committee members yawn not too long ago, so I will try to keep this brief. And I just like to take my time to highlight the similar work that's already being undertaken by the Commission right now. First, comprehensive interconnection rules that satisfy the requirements contained in this bill are currently in place. As a result of the substantial changes to the grid and the interconnection processes resulting from significant increases in distributed generation, the Commission has made periodic changes to its interconnection rules. The Commission also has, as has been acknowledged, we have a pending inquiry regarding additional changes to the rule. We also anticipate opening a rulemaking process regarding Chapter 324, the small generator interconnection procedures. This rulemaking will consider cost allocation requirements with respect to interconnecting customers. And then last, just with respect to Section 2 of the Act, the Commission is in the process of contracting with an expert consultant to provide for a comprehensive review of the future requirements for the grid to accommodate the transition of beneficial electrification and allow for transparency of interconnection screens and upgrades for customer-sited generation. Responses to the Commission's RFP for this consultant are due in a week or two on April 22nd. In short, we are on it. The Commission welcomes any questions, and we will be present for the work session.
Great. Other questions from the committee? Representative Foster.
Thank you, Mr. Chair. Thank you, Mr. Corbin, once again for being here with us. I'm wondering if you have the ability to share at all, at least what the technical background is of your consultant in regards to what you've just talked about looking at this research that PUC is undertaking.
Sure, yeah. Just to clarify, we have the RFP open right now for that consultant, and that closes on April 22nd. So we haven't selected the sort of winner of that. But we can, I think what I can get you, at least for now, is the what we had, the RFP itself and the qualifications that were requested.
Any follow-up, Representative Foster?
Yep. Yes, thank you, Mr. Chair. And if I may, I am concerned about that because much of what we've heard here today reflects back on concerns that have been raised by some on 1711 and other legislation passed and present that, and we heard from the governor's energy office what they must have and what we must do. But quite frankly, the plan with any details not there. So I'm concerned that the PUC, who I quite frankly depend on to bring some realism and some common sense to the table, along with technical expertise, is making sure that they have somebody to support you in that. That is in fact going to be able to look at this not from a philosophical point of view, but from an actual point of view. So again, I would just ask that when you have that information, I'd like to know who that is or what their expertise is if you can't share that. Thank you.
Fair enough. Yeah, will do. Thanks, Representative Foster.
Great. Any other questions? Representative Berry.
And thank you very much, Senator Lawrence. Just pulling up the bill, and I want to make sure I understand, Mr. Corbin. So in the existing dockets, the existing inquiries, do you anticipate that the commission will be adopting rules? I mean, we've heard it described by a business that, a small business, 30 employees, that this is a real emergency for them, that, they're bumping up against, interconnection rules that are intended for, projects hundreds of times bigger than the ones they're building. So is rulemaking, I mean, I don't think anyone disagrees with best practices for interconnection rules. I can't imagine that there'd be disagreement about timely resolution processes that don't place an undue burden on the customer. That seems commonsensical. Coordinating load upgrades and infrastructure, utility infrastructure upgrades. Are you able to commit to us, or could you, for the work session, really give us a little more clarity about whether these things will be done? Because I mean, these seem obvious to me. They seem like of course they should happen. And I think we heard from the governor's energy office that they too would like a little more clarity there. So I'm just not, I feel like, maybe we don't need to pass this, but I don't feel that we have the clarity now to say that.
Sure. Thank you, Representative Berry. I'd say a few things. Just first, I think today is the first time that we had heard directly, or at least through this hearing, that there's an interest in or a sense that there's insufficient clarity. So let me see what information we'll try to get you as much as we can for the work session, if not sooner, on exactly how we are undertaking this. But as you know, with all of our processes, stakeholders are, not just allowed, but encouraged to participate. And so I think these, topics, if they haven't come up yet, certainly are bound to. And I don't think, I just note our testimony is neither for nor against. We're not objecting to this. We're just trying to ensure that the committee knows that this is something that the commission takes seriously, and we are working on it with as best as our resources allow. In terms of again, more detail, time frame, clarity, I will get you as much as possible for the work session. Hopefully it's what you're looking for.
Thank you.
Any follow-up, Representative Berry?
I'll leave it there for today. Thank you, Mr. Corbin.
Any other questions from the committee? None. Thank you very much, Gordon. We'll go on to James Cody from Versant Power, testifying neither for nor against.
Thank you once again, Senator, Representative Berry, and members of the committee. Again, I'm James Cody on behalf of Versant Power today. Versant Power testifies neither for nor against this legislation, and frankly, to highlight many of the things that you've already heard. One is that there is this existing investigation and public dialogue happening at the Public Utilities Commission. So we've sort of got that dialogue in motion. Secondly, we wanted to point out that there is a working group comprised of developers and utilities and other stakeholders that are actively talking about interconnection issues on a monthly basis at this point. So that dialogue is also happening in that venue as well. We believe that certainly those two conversations are helping to alleviate some of the problems, but they're not perfect. So we certainly understand the goal of this bill. What we thought was really important to point out is that while an important part of the process is only one aspect of apologies here, I'm losing my notes. What I'm trying to get at is an essential component of trying to alleviate these problems and fix them for developers and others alike going forward into the future is not just trying to fix the system that we are trying to fix today, but it's about implementing a forward-looking process that which we refer to as integrated resource planning or integrated grid planning, where the utilities and developers and other stakeholders can come together and begin to put together a blueprint for where projects are best sited in the future, which can alleviate interconnection hurdles and drive down costs for these projects. On behalf of Versant Power, we would like to have that conversation with stakeholders. We'd like to figure out how to get there, but that probably needs the legislature and the PUC to be on board with that sort of process as well. So I'll wrap up here, but our point being, let's not just focus on fixing the old problem, but let's look forward and begin to implement a plan for how developers and utilities can integrate in the future for the best possible projects at the best prices for customers with the least amount of policy hurdles. Thank you for your time. I'd be happy to answer any questions.
Any questions from the committee? Seeing none, thank you. And our last person testifying on this legislation is Jim Mitchell on behalf of CMP.
Jim is not currently on the Zoom from what I can tell, so I don't believe that's going to happen.
Okay, is there anybody else I missed, Jordan?
No, Jim would be the last one, but he's not currently here.
Great. So do you know if he's submitted written testimony to us?
Let's see. Yes, he did.
Good. Well, I'll just direct the committee members' attention to that written testimony. And without any further ado, I'll declare the hearing on LD 1100 to be closed. So good day on a long day, everyone. Congratulations. We have an equally long day tomorrow. Tomorrow is Electricity Day, where we're going to hear kind of a broad overview of perspectives on what's been happening in the electricity market and the things we need to think about in a broader kind of 30,000-foot view on electricity and planning for the grid. We'll have the COUs and the IOUs speak. We'll hear from several public agencies, as well as several people on the production side and on the consumer side too as well. And the purpose of this is not to talk about current pending legislation before our committee, but just get to them maybe a little bit more detail and a little bit more overview of what's happening in the industry and what they see as the challenges over the next 3 to 5 years. If you haven't done so, you can get questions to Deirdre, and she can pass them on to the people presenting so that they can present that. And just a brief update for all of you and those of us on the subcommittee on net energy billing. We met on Monday. We had a good session, lasted about 2 hours, and we sent out a lot of requests for information. So after our long day tomorrow on the energy briefing, we're going to get together. I think it's 3:30, so look for a Zoom link to see that information coming back to us. And we hope to start getting some stuff back to the committee as soon as possible on net energy billing. Representative Cuddy.
I just want to let you know that I will likely not be here tomorrow. We have 10 bills in work session for labor and housing tomorrow morning.
I'm sorry, but you can't do that. Any other comments, thoughts before we check off for the day? Okay, thank you again, and see you all except Representative Cuddy tomorrow morning. Take care.
Night all.